Good morning, Nishu. मैंने कर ली। I
Good
said
morning, ma'am.
I don't know आप अभी कब करना चाहते हैं? मैंने बोला है. Good morning, Nishu.
Good morning, ma'am. Should we start, ma'am?
I'm not able to hear you. Am I audible to you?
Yes, ma'am. You are audible.
Good morning,
Ma'am,
Nishu, ma'am.
Ma'am, should we start?
I'm not able to see. I cannot listen your voice.
रुक जा, मेरी आवाज नहीं आ रही है.
Yes. मेरे बंद है.
मैडम को नहीं सुनाई दे रही है. हेलो.
आपकी वॉइस गूंज रही है निशु. Some more of the equipments are near you.
Hello. Good morning, ma'am. Am I audible to you?
Yes, yes. Very much. Good morning to you.
Should
Yes,
we
I'm
start?
now. Am I audible to you?
Yes, ma'am.
Would we do we have has our resource person joined?
Ma'am, yes, sir. Yes, ma'am. Mr. Rajput has joined. Vipin sir is going to join shortly.
Kindly request him to join before we start.
Okay, ma'am. Okay.
और कोई नहीं है? रिया, डॉक्टर सीमा सिंगल, नंदनी, किरण आगरा, अंकिता।
Hi.
A very good morning and a hearty welcome to everyone. Am I audible? Good morning.
Good morning, ma'am.
Good morning, ma'am.
A very good morning and a hearty welcome to everyone in today's national online webinar on the topic Intellectual Property Rights, organized by Department of Commerce of M.D.S.D College under the aegis of Institutions Innovation Council. I, on behalf of whole M.D.S.D College team, would like to express my thanks to Mr. Pranav Rajput and Dr. Vipin Saini, our today's resource persons of webinar, for sparing their valuable time to share their knowledge on the topic with us. Without taking much time, I would like to invite our worthy principal ma'am, Dr. Kiran Angra, who has always been a source of inspiration and motivation for all of us. For her presidential address and to give a formal welcome, Ma'am Principal.
Thank you, Madam Nishu Bansal and Seema Agarwal ji, the convener of this event, and Nishu, the organizing secretary of this event. Dear friends, we are very much pleased to welcome these accomplished experts in their field, the two resource person, to this national webinar being organized by the Department of Commerce. We have with us Pranav Rajput ji, who is a legal executive in British Columbia and has done his Masters of Law from Queen Mary University, and has in Justice Institute of British Columbia. So it's a proud privilege for us to have Pranavji with us. He is a brilliant son of our learned resource person, Namita Rajputji. I hope it will be very beneficial for you being with us. Our second resource person of today is Dr. Vipin Saini, who is working as a director, research and administration, advisory councils in the deemed to be University Mulana. And he has more than 150 patents to his credit. By this small introduction, while the elaborated introduction of both of them will be given by the convener and the organizing secretary in the journey of the seminar. I welcome here the academicians, the delegates who are presenting their papers on the different sub-themes, and the vibrant participants who are eager to understand, who are eager to know about this burning topic of today's. No doubt, friends, the origin of international IP regime was in Paris Convention for the Protection of Industry, Property and Inventions, way back in 1883. While in 1893, United International Bureau for Protection of Intellectual Property was constituted. But the Indian government has approved its first IPR policy in May 2016. As we all know, because number of seminars has been witnessed by this college, either through offline or online. So by this time, I hope you have understood that various components of IPR are the copyright, patent, and trademark. And other type of right include trade secrets, publicity rights, and the right against unfair competition. Example of IPR rights also include patents, domains, industrial design, database rights, logos, and computer software too. Owner of intellectual property frequently use more than one of these types of intellectual property law to protect the same intangible assets. For instance, for an example, the trademark protects the product name, while the copyright protects or it covers the tagline. My dear friends, in this 21st century is known as the century of innovation, education, and intellectual regime. The intellectual property rights are critical to any country's development or economic prosperity, like the developing countries of ours, India. If I hope many of you may be knowing that now the GI indexes, the GI tags, either on the sarees or on the southern toys or on the chutneys even, which are prepared by the white ants, have or on this, I was telling the GI tags have also come into pictures, which I hope both the resource person will be talking about. People are now very much conscious that the things which are being done by them, the bills which are being produced by those states even, they should be their protection, they should be protected by this law. Otherwise, the countries which are developing countries, they may put their patents over there. Like we all know, the haldi has been patented by, the neem has been patented by America. Though we are using these Ayurvedic things have been put into various Ayurvedic medicines put by the very pharmaceutical companies since years back. So the person has to get very much. The teachers are also getting aware nowadays, as in the academia, a lot of patents have been produced in the sciences, and the things are going on in the different fields others. I hope this seminar aims to throw light on what are the intellectual property rights and how they are beneficial in the today's world. I have seen Dr. Vipin Saini, who has joined just now after a sorrowful event happened to their community or in the university. We are very thankful that in spite of that rider, you are with us. I'm thankful to Pranav, who has been very accurate and has joined by the IST time, very much in time with us. Thank you very much. I hope your deliberations will surely be fruitful and knowledgeable to the students who are also in the organizing committee of this seminar. And they may also learn, because they are going to become the young entrepreneurs of the future. Thank you to all of you. And my blessings to both Seema Agarwal ji and Nishu Bansal to take the seminar, to take this webinar ahead. Thank you very much.
Thank you, ma'am. Thank you very much for your kind words. Now, I would like to invite our first resource person, Mr. Pranav Rajput. He is a young, dynamic, and energetic person who had done his PG diploma in law enforcement from Justice Institute of British Columbia and has done his master's in intellectual property law from University of London. He has a good experience in the field of law and IPR. He has worked as a legal executive with various renowned organizations in India and British Columbia. He has also published a book on intellectual property rights. Although the list of his achievements is very long, but keeping in mind the time constraint, I would like to invite Mr. Pranav Rajput for his deliberations. Pranav, sir.
Thank you so much for the kind words and having me over. And it has been a pleasure. I am kind of bummed that I am not able to do this in person, but I guess the technology has taken a leap forward and we can do this online. So might as well start with this. And my greatest gratitude to everyone present here on the seminar. Thank you for taking out a precious time for this lecture. So basically, more or less, just to tell you about myself, because I think the DICE has done an excellent job in explaining what I've done up until now and what I'm up to. So I've kind of after completing my law, I did my law from M.D.S.D Delhi, and I immediately, to just feed my intellectual curiosity, I went to do my master's in intellectual property, because that avenue of law was something that intrigued me since the start of my journey as a law aspirant. I was fortunate to have a lot of mentors in this field, and I believe that mentorship is very important for somebody to be guided, if at all the chosen path is intellectual property. So I was blessed to have mentors, and one of them is no more. So I would like to pay great regards, because during the time of COVID, I had lost my mentor of intellectual property. So I just want to pay my gratitude to her. Because of her, I am here, because she wrote my letter of recommendations and whatnot. So yes, more or less, my life has been about IP. I did my intellectual property, my master's in intellectual property from Queen Mary University of London. It was a very intriguing experience. And I believe that if at all anybody who is interested and is a law student and wants to take their journey forward in the avenue of intellectual property, they should be doing that, because IP is an avenue of law and an avenue of a general conceptuality which is gaining momentum on many folds. IP is a booming concept, and there are a lot of concepts that are coming on, and there is a need to get the IP protections on each and every thing which is related to law. So now I would begin with my presentation, and thank you for bearing with me. So just I would want to ask the students, because obviously the learned principal is well acquainted with the concepts of IPR, as I could figure out from the introduction. So I just want to ask the students. So guys, do you have any idea as to what IPR is in a layman concept? And if not, it's not a big issue. I just wanted to know where are we, so that we can have a level playing field and start off with the lecture. So students, do you have any idea about what is intellectual property?
Yes, sir. Intellectual property basically means the creativity of an inventor's mind.
That's
Means कुछ भी new invent अगर हम करते हैं, so that is basically intellectual property which we have created the property by using our own intellect, and we are what we are doing, we are getting it protected through the IPR, so the intellectual property rights, so that other person cannot reap benefit from our creations for the particular time period or in long run.
yeah, amazing. That pretty much sums it up. I don't think so. I don't even have the need to explain any further, but that was perfectly explained. And as the name suggests, intellectual, so it is incorporeal and intangible in nature. And it is probably a sweat of brow. जैसे एक पसीना छूट जाता है जब हम कुछ मेहनत करते हैं, तो there is this doctrine of sweat of brow, which entails the concept of intellectual property, that I've put in my labor, I've put in my intellect, I've put in my time, I've put in my money into something which has now getting embodied in a form of a literary work or a novel. I would want to have protection over it. So that's where the intellectual property rights come into play. So extremely well explained, I must say. Thank you so much. So intellectual property rights are legal rights that protect the creations of human mind, such as inventions, literary works, artistic works, symbols, designs, trade secrets, as what we have discussed before. And there is an organization which caters to the international administration of intellectual property across the globe, which is called as WIPO, World Intellectual Property Organization. So that kind of lays down and very meticulously tells the ratifying countries that what ought to be the laws related to the intellectual property. So as what I discussed, WIPO. So now I would like to throw light on certain aspects of WIPO. What is the main idea behind WIPO, and like why was it incepted, and what was the main rationale behind the establishment of WIPO? Basically, it was to develop international standards of intellectual property. So if there are international standards which are laid down by the intellectual property, so it becomes very easy for the ratifying countries to incorporate those standards into their domestic rules and regulations and laws or policy making. So if there is a threshold which is to be met with, if I've ratified with WIPO, then I have to adhere to those thresholds or those standards which are set by WIPO. So that is what precisely is WIPO doing, administering the intellectual property laws across the globe. It also promotes the use and protection of intellectual property and so on and so forth. So this is actually the international body which governs IP. So now WIPO, as the name suggests, has been very meticulous in explaining the different types of IP. The first, as the learned principal has already explained, the few types of IP, I would just briefly touch down on these concepts. The first being copyright. Copyright, obviously, it's a legal term which is used to describe the rights that the creators have on their literary or artistic works. So if I'm a novelist, I will claim a copyright over it. So now, if we talk about patent, and like patent is a North American pronunciation. Some people call it patent, some people call it patent. So to each his own. So I call it patent. So throughout the course of this seminar, I'll be pronouncing it as patent. So patent is an exclusive right which is granted for an invention. Sometimes people who are oblivious with the concept of IPR, they use these terms synonymously, like copyright, trademarks, and patents. So just so that it does not happen, and we being the academicians as we are, we should be knowing the difference between all of these. So copyright is something which you claim over your original artistic or literary work. Patent is always granted on an invention. Trademark is basically a sign which is capable of distinguishing the goods and services of one enterprise of those from the other enterprises. For example, if my phone on the back of the screen has Samsung written over it, so this is trademarked. Samsung is trademarked. So it distinguishes the product from the other phones which are prevalent in the market. For example, Motorola, Micromax, and whatnot. So if I have a trademark, it basically enables the people and the person who owns the product to distinguish the goods and the source of origin of the goods. Trade secrets. Trade secrets are also a type of IP which is based on the pretext of confidential information which gives them the edge over their competitors. Trade secrets is a very interesting concept, so I would like to discuss it as and when I reach on to the part where I'm discussing trade secrets in the PowerPoint presentation. Geographical indications was very much articulated by the learned principal. She, I must say that the amount of knowledge she had about GI tags was amazing. I am very impressed. So GI is basically an area which is growing, and it is a sui generis legislation. Sui generis means it is tailor-made, because sometimes the product is revered by people by the origin of it. जैसे कि if I talk about saris, which is very much popular among women, because obviously women wear saris. So Kanjivaram silk is a silk which is used to make those saris sometimes, and that the quality of silk it has Kanjipuram with it. So it tells the appellation of origin, which makes the product more appealing and more revered and more sought after, like Greek yogurt. And I'll give more examples as and when I reach on the slide where I'm discussing geographical indications. So this was more or less about like a bird's eye view on what intellectual property rights are. And these are being also laid down by WIPO. So why is intellectual property so important? I guess from the start of the seminar, we have been discussing that we do not want somebody else to write the labor that we have put in and reap the benefits out of it. Because obviously, then people will stop innovating. If I do not have confidence that, okay, if I'm putting down something on the paper, and if I'm publishing it, and if I do not get this thing under my control and other people are using it without my permission or without the necessary procedural and legal requirements, then why would I innovate further? Because I would be having great amount of apprehensions that my work is going to be stolen. So why intellectual property is so important is because of the fact that an author or a person who has made a product should reap the benefits out of the labor and the amount of R&D being said, which is research and development, which he or she has been putting ever since the concept has been arised in her or her mind. So I believe that is why intellectual property is very important, so that no one else or we preclude the other people from reaping the benefits out of our labor. And please, guys, please feel free to stop me anytime if I go fast, because I have a habit of going very fast or sometimes very slow. So please, if I'm not according to the speed, just prompt me and I'll be as per your convenience. So yeah, that's precisely why IP is required, because it's my idea. I want to protect my idea, intellectual property rights. Now, I chose this slide because I believe that this has a reputation which everybody knows. So I wanted to ask the audience, do we know about Marvel Comics Universe, MCU, and do we know about Stan Lee? Or probably we must be knowing about Spider-Man, right? So I've taken this example. This guy with the spectacles on, he is an icon. He's no more in this world, but he is an icon. He is somebody who has created a $1 billion business out of writing comics. So this guy's name is Stan Lee, and he's basically the guy who has been designing the characters of Marvel Universe, such as Spider-Man, Deadpool, and whatnot we have been enjoying since the movies have been started to produce. I took this example for the very fact because when Stan Lee was making these characters, the intellectual property regime was at its rudimentary stages. It was very much in the beginning. So he was oblivious and he was not acquainted with the idea of getting the protection done. And now, because of that, and now I will unravel how it was very much adverse for Stan Lee, because he was not able to protect the work that he had done. And we all know the profit which these comic movies earn, and I think it's huge. It's exorbitantly high. So had it been the case where Stanley would have protected his creation, I guess he would have been the one reaping the benefits and not the Marvel comic universe. So in the next slide, it will just give you a brief timeline of how the legal battle went with Stan Lee. So Stan Lee and Jack Kirby, you can see the year is 1939. That's when probably Stan Lee created the first Marvel comic. And then it started to gain momentum. It got popular among the youth, and not just among the youth, among all ages. And people started to revere what MCU is, because it was obviously sci-fi, and sci-fi was the trend, and because Star Trek and all of these things were going on. So at the same time, parallelly, Stan Lee decided that, okay, this is something which is going to be huge. So when Stan Lee had that epiphany, okay, I need to protect my rights. That was very late, somewhere in 1970s, when he thought to that he wanted to get his ideas protected. But that was too late, because Stan Lee in 2002 lost his legal battle with Marvel. But as we know, we have seen MCU movies. There have been cameo appearances of Stan Lee in all of these movies until he was alive. That was because they reached an agreement with Marvel, and obviously an amount was set aside, and it was an out of court settlement, and Stan Lee got a major chunk. But what I believe was, had Stan Lee been more prudent, he would have been a billionaire before resting in peace. He would have been a guy with more fame and more money and ever before, because all of the benefits were reaped by Marvel. So I believe that if at all you have anything in your mind which you believe that, or even if you don't, because future holds no certainty, but if you have any concept or any idea, just get it into an expression and get it protected, because you never know. I will give you another example. If people are oblivious with the concept of Marvel Universe, we all have heard about Harry Potter, right? J.K. Rowling is a very meticulous author. She wrote a book called Harry Potter and the Sorcerer's Stone. Little did she know that it's going to turn into a multi-billion dollar business. So what happened? She started writing books. The books became popular. She never knew that it's really gonna go so exorbitantly high that like people would across the globe would know her name. But the very fact that she had protected her IP, she got the novels all copyrighted. That's where she had the liberty and the leverage over the people, like the HBO or whosoever was producing Harry Potter at that time, that okay, this is my creation and you need to give me this much amount of money, this much amount of royalty, only then I will be able to give you the license to use my work. So that's where J.K. Rowling was smart. So yeah, so just these two examples where small characters or small novels have taken a leap forward and turned into multi-billion dollar businesses. We can see Harry Potter merchandises, we can see Disneyland, we can see whatnot. I mean, there's a lot of merchandising, then there's a lot of corollary to it, which makes it a billion-dollar business. So I believe it is just by the virtue of IP protection that they were able to create such a big business. I studied a module, I remember, and I remember from on the top of my head, it was called IP in business, and a very renowned professor taught me when I was in when I had my time in London. So he told us, and we were actually very astonished that okay, how can one book or a series of novel get transformed into a multi-billion dollar business? That's the strength of IP. That's where you have to get it protected. So yeah, comics made by Stanley were wealthy and famous, as we all know, and it obviously created the lucrative Marvel universe. But obviously, by making and giving up his IP rights, he was not there where he should have been. So Marvel Studios has obviously acquired the right to use Stanley's name, voice, likeness, signatures, movies, projects, and everything. So I think Marvel is at the advantageous position, and I chose this example just to make it more interesting so that it's not just boring and pure text explaining what is IP. So yeah, I just wanted to take these examples. Sorry. So yeah, intellectual property is the right of an individual, just like on any other asset or property they have. Like I said, it is intangible. The only tricky part is the intellectual property is the sole product of one's mind and innovation, as an idea or as a thought can be stolen by anyone used to their benefit. There are a lot of rights in place and maintain the safety of intellectual property, protect your idea. Now, I wanted to tell there is this lacuna that falls into this conceptuality of IP, that like where does IP lie? मैं ऐसा क्या करता हूं कि मुझे वो protection मिलेगी? So obviously, this is a slide which just gives you a bird view of all the IPs. So what will I do so that I get a copyright, or what is there? What is the locus that I am asking for the protection? So this is copyright, and our Copyright Act was like very articulate. It basically gave us the idea of the subject matter on what is under the purview of registration. So yeah, it ensures protection. It like it enriches the originality of the creation. And now with the first and the foremost part, the doctrine of originality actually mongers the concept of copyright. It has to be original. So now I would like to touch on the concept of idea and expression dichotomy. There are two separate things. One is the idea and one is the expression. For example, I'll just give you right now, like two people are talking. मैं और मेरा एक दोस्त बात कर रहा है और मैं उसको एक आइडिया देता हूँ कि चल आज हमें क्रिप्टो करेंसीज के ऊपर कुछ मिला है और आई थिंक आई कैन मेक समथिंग आउट ऑफ सम रिसर्च पेपर आउट ऑफ क्रिप्टो करेंसी. और दूसरा दोस्त जो है उसका वो बोलता है हाँ ये बहुत अच्छा आइडिया, बट द फर्स्ट पर्सन हु एक्चुअली कंसीव्ड द आइडिया डिड नथिंग अबाउट इट. It was just in an idea form. There was no expression to it. But the other guy, taking the advantage of the situation and bearing in mind the cryptocurrency's lucrative nature, he decided to write a research paper and get it published. And he also wrote a novel. He also wrote a book pertaining to cryptocurrencies and intellectual property, and now has started to get royalty. The other guy comes up the other day and says, okay, you stole my idea. तूने मेरा आइडिया चुराया, तेरी वजह से रॉयल्टी मिल रही है तुझे और मुझे मिलनी चाहिए थी क्योंकि मेरा आइडिया था. No, that's where he's wrong. The copyright protection is not on the idea but on the expression. So that is the principle of idea and expression dichotomy. So the law must protect the original work and thereby allowing to reap the fruits of the labor and stopping the unscrupulous pirates from enjoying those fruits. And the second policy is like obviously overprotection also curbs the creativity. Agar har jagah hi protection hogi, so there would be no room for inspiration. We all have must have known about James Bond in our lives. We must have heard about James Bond. So that was an inspiration by a book written by Mr. Ian Fleming, a very articulate author. He wrote on espionage. He had his forte in writing about spy and espionage. So he wrote this book which gave birth to the character of James Bond, Mr. Ian Fleming. So if the protection is overly protected and if it is overly fortified by the authors or by the creators, then there would be no room for the other people to get inspired from. So there has to be a balance of protection and giving the people liberty to get inspired from their work. So there has to be a balance, a level playing field. So there's a balance, and it doesn't curb a future innovation, because people would stop innovating because they'd be like, okay, if I start something, people can sue me. So why would I start? Because obviously, who wants to get into legal troubles? So that's why overprotection also is not a very good idea. There has to be a significant balance among the two. That is the protection and overprotection. I believe up until now, I'm making myself clear and going through the concepts in a good pace. And this is just about copyright. I'm just talking about copyright right now. Okay, just to please the audience of the past, the plaintiff in this case, R.G. Anand versus Deluxe Films, it is a Supreme Court case and a landmark judgment. And if at all I have any law student present in this seminar, I would really request them to go through this judgment, because obviously due to the time constraint, I won't be able to incorporate each and every nuance of this case. So I'll just give you a brief explanation. The plaintiff had written this play called Hum Hindustani, and it became very popular. And in 1954, the defendant, Mohan Sehgal, the director and the producer, had sent a letter to the plaintiff wishing, telling him that, yes, this is something on which I want to work and I want to make a movie out of it. The plaintiff and the defendant discussed the case and the entire play, but the defendant did not commit to anything. The plaintiff, and there was this movie, as we can see in the PowerPoint slide, called New Delhi. This movie was based on Hum Hindustani. So the idea was of the play, but this was a mere adaptation of that work. So New Delhi had a new expression to it. It had a new adaptation to it. So the Supreme Court finally reached to the verdict where it said that, okay, this is not infringement because copyright does not lie in the idea. The copyright lies in the expression, which was given by the director of the movie, because there was a cast, there was choreography of the movie, of the songs in the movie. There was screenplay, there was cinematography, there was everything. So that gave a new dimension to the play, which was just words. So the inspiration came from the play. So I would genuinely request all, like everybody who pertains to be a law student, this is a landmark judgment, R.J. Anand versus Deluxe Films, and you would want to like go have a thorough reading whenever you have any exam, or like just to feed your inquisitiveness. So yeah, I believe this is a landmark judgment and everybody should be acquainted with it. So now there is also a test of substantial similarity. The landmark judgments have been cited, and I can tell it to you later. Now we have seen the OTT has come onto the trend. Like we've seen like few shows which are getting notoriously famous, like Fuzzy and whatnot. So all of these OTT platforms are doing amazing right now, and I think it is a very novel avenue for newcomers to have their work done. So now the thing is, OTT has created a different and a parallel intellectual property regime, which I will explain now in the upcoming slide. Yeah, okay. So first of all, I would like to throw light on the subject matter of copyright. So these are the things on which a copyright can be sought on: musical works, literary works like manuscripts and books, performances. Like, for example, if I'm doing a choreography and it has certain steps and I've written those steps down, I've written the whole idea about that dance routine, and I've written everything in an expression form, then obviously that can also be copyrighted. A cinematographic film can be copyrighted, fashion designs can be copyrighted, artistic works like painting can be copyrighted. Can anybody tell me any famous painters like Maqbul Fida Hussain, for example? M.F. Hussain was one of the icons, and one of the like he was the epitome of art, I believe. So all of these things are subject of copyright. Um, Again, I'll just quickly give a brief through: musical works, cinematographic films, sound recordings, fashion designs, performance, everything. For example, if I've written a song, and with the song I have written the lyrics and the song and the notations along with it, then it is obviously under the purview of getting copyrighted. Now, the concept of originality only lies with dramatical, musical, and literary works. The concept of originality does not lie in cinematographic films or sound recordings, because like obviously I'll explain it later, but the concept of originality remains with the artistic, literary, and authorship works. Now, a cinematographic film can be defined by any visual recording of any medium created through the process of moving image or anything. As explained, as we can see, and we have seen movies, we are not oblivious to the concept of movies. So movies in itself, they are a part of copyright, and obviously the producers, like a relevant section, I'll tell you, it is section 16, which tells about authorship vis-a-vis ownership. All the rights of a film is owned by the producer of the film. And yes, cinematographic film is a major part of copyright, and you can claim a copyright over a movie. Now, we must have seen there are a lot of remakes that happen. Like, for example, there was this movie Golmaal, which was released in 90s. Now there was another movie called Golmaal, which came in 2000, and that was not exactly the same movie, but inspired from it. There are a lot of movies, not just one example. So there are adaptations. So that's why I'm saying the concept of originality does not stick with cinematographic films and sound recordings, but with the others. Yes, as I said, do cinematographic films require to be original? Originality. The act does not require originality like literary, musical, and artistic creations. Look, these three things strictly need to be original. Literary, musical, and artistic creations need to be original. But copyright will not exist in a cinematographic film which is substantially a part of another work. Then it will not. But if at all, I have changed the theme, if I've changed the characters, and if I've changed the dialogues, if I've put in movies, if I've totally make it, if I've totally made it into a new adaptation, then a cinematographic film is produced. That's why I say the concept of originality cinema does not lie with cinematographic film. हम कितनी कितनी movies देखते हैं और कितने songs देखते हैं जिनका remake होता है, जैसे हवा हवाई करके एक बहुत ही popular गाना था. Now in a movie of Vidya Balan, the Hava Hawaii song was made again. Many Punjabi songs have been now, which were icons of their time. Ishq Tera Tadpawe. All of these songs have like taken a leap forward and now have their adaptations. So as we know, वो गाना जो अभी बना है वो ओरिजिनल नहीं है बिकॉज वो पहले भी बन चुका है. बट जो जिस तरीके से वो अडेप्ट हुआ है सॉन्ग, जैसे उसमें वो चेंजेस हुए हैं, जो म्यूजिकल नोटेशंस के चेंजेस हुए हैं, लिरिक्स ऐड हुए हैं, और मूवी में भी सिमिलरली जैसे हमने उसमें एक नई थीम डाली, हमने कैरेक्टर्स डाले, हमने एक उसके अंदर एक पूरा प्रोसेस डाला है, तो इसीलिए उस चीज को ओरिजिनल होने की जरूरत नहीं है. It can also be an inspiration, as I said before. Yeah, like the example here. One second. Yeah, the version recording of this song was already published before. But now, as we can see, the Vidya Balan movies had that song Hava Hawaii too. So we know this song is still in our hearts and it's still very relevant. So people have made an adaptation out of it, and they've added a lot of other things to the song, which obviously makes it a different song and thereby precludes infringement. So this is not an infringement. This is an adaptation. This is like how we are getting inspired from the old songs and making it to the new ones. So now, this is a very counter intuitive like concept in copyright. The concept of fair dealing. It is purported by Section 52 of the Indian Copyright Act. So now, what does fair dealing mean? Fair dealing basically, this concept, this doctrine entails the fact that there are certain things which I can do or people can do, which may in other circumstances would amount to infringement, but are not infringement. For example, अब जैसे किसी की भाई किसी की जान was notoriously famous for its bad reviews, right? So people, while giving reviews, they use the clippings of the movies, right? So if I'm a YouTuber, if I'm an influencer, and if I have million subscribers, and I am and the title of the and the title of the video is "Kisi ka bhai kisi ki jaan" review. So if I'm reviewing, and in that and by the virtue of that review, if I show the whole movie in the review, that will be infringement, because that is not a review. I've given the producer's work and the artist's work for free just by the name of review. So that is infringement. But if at all I take clippings out of the movie, I give my own commentary to it, and if I give my own analysis of the movie to it, then it does not entail to infringement. This is concept of fair dealing. Now, secondly, if I'm using an article for my own personal use or private use, which may include research, then it will not amount to infringement of copyright. For example, if I get the book and I've not purchased the book, but I'm just doing, if I'm writing it, I'm just reading it for my own pleasure, and if I'm doing it for my own research, and giving due credit, then obviously it's not criticism. It is not infringement of copyright. So criticism or review, whether of that work or of any other work, as I said and discussed, the review will entail to infringement if substantial amount of the work has been added to the review, then obviously it will amount to copyright infringement. And reporting current events and current affairs, including reporting of a lecture delivered in public, this is not copyrightable. I mean, if there is a cricket match, I cannot claim a copyright over a cricket match. But obviously, I can have the broadcasting rights to myself. For example, Geo Cinema has the broadcasting rights, exclusive broadcasting rights of the IPL 2023. So they have the copyrights on broadcasting, but they cannot obviously copyright the match itself. The match is a current event. News cannot be copyrighted because it is a natural phenomenon. So yeah, all of these things cannot be copyrighted, and they all are governed under the doctrine of fair dealing. Um, Tony Kakkar is obviously trolled enough. I don't know, but like it is the new age. Like YouTubers have started this trend of roasting people. So yeah, Tony Kakkar is among those unfortunate people who has been a target of many YouTubers to get roasted on. So now, if I have to review a Tony Kakkar song, I like in one go I can only use 5 seconds of that clip. So that's what it says, and it is in the YouTube guidelines as well. If I have to get a review, I have to take a 5 second clipping, and if it is more than that, I can have my video been taken down, or the copyright holder may have the monetary benefits which I would have reaped out of it. But obviously, being the copyright holder, he would have the monetary benefits. So yeah, it has to be for 5 seconds, and then there should be a commentary, then another 5 seconds, then a commentary, then another 5 seconds, then another commentary. This is how it goes. This is how the process of review goes. So yeah, just an example. Trademark, guys. I'm so sorry. Copyright was something that I have put in a lot of work, so that's why it got a lot stretched. I'm sorry for that, but yeah, we cannot discuss each and every IP in detail due to the time constraint. So now I will just briefly discuss the concepts here on. Now, Trademark Act 1999. So trademark can be any word, phrase, symbol, design, or a combination thereof, which signifies or identifies your goods or services. This is what is meant by a trademark, which has the capability of distinguishing the goods of yours from your competitors. So if I have a Samsung phone and if I have an Apple phone, we both know the difference. We both know that, yeah, this is Samsung, trademarked by Samsung. This is Apple, trademarked by Apple. The button Apple is obviously a trademark symbol. Samsung's logo is also a trademark symbol. So all of these are trademarks. Why we trademark? Because obviously, once if I'm wearing a Rolex watch, people have that reputation in their mind that okay, Rolex is a watch company which is very precise, luxurious, a status symbol. So if somebody is wearing that Rolex watch, it will instantaneously occur to me that okay, this guy might be rich, or this guy might be influential, or this guy might be a very big personality, because we have seen Rolex collaborating with icons like Roger Federer, who has been like a major name in and greatest of all times in tennis. So if I see, and by that virtue, if I see somebody wearing a Rolex watch, I would instantly feel that okay, this is a good watch. But if somebody makes a watch called Rolex, and it is obviously very much, and if I give a very similar touch to it, like a Rolex, if I give a date just or a date, these are all the models of a Rolex of the Rolex company, then people would be like, okay, that's a Rolex watch, but that's actually not a Rolex watch. From a distance, you can feel that it's a Rolex watch, but actually that's not a Rolex watch. So that guy who is making the pirated versions of that Rolex watch reaps the benefit of the goodwill of Rolex. So that's why it is very important for a person to have their goods or their services trademarked. Rolex, by the way, is an example of a well-known trademark. Functions of trademark. In India, the trademark performs the following functions. It identifies the product and its origin. It is basically the main function of a trademark. It identifies the origin. Okay, if it has a bitten apple behind the back of the phone, it is from Apple. That's where I connect. That is the origin. It proposes the guarantee of the quality of the product. Okay, if I have a Rolex watch, if I have an Apple phone, I know the Apple phone is not going to hang, and I know that the Rolex watch is going to show a precise time no matter what. So that guarantees the quality. So that is why there is a dilution. If I like, have we, like, we all must have lived in the era of Chinese phones. So research in motion, there's this Canadian company um, that actually made BlackBerry. I think we are all aware of BlackBerry phones. So back when the Chinese market was at its peak, there were copies like Black Cherry and Blueberry, and such phones were made, just trying to reap the benefit of the goodwill of BlackBerry. So if I'm making those products, obviously people are going to buy and thinking that, okay, it's a BlackBerry phone, I'm getting it for a cheaper price. So they're going to think, and it's going to create a confusion, and obviously the product being deceptively similar to BlackBerry, people will buy a Black Cherry as well. And obviously the quality and the origin is not true. So obviously if any malfunction happens, people will say, okay, BlackBerry sucks, and people will be like, all this high and mighty reviews about BlackBerry is false, because as in when I purchased my phone, it got hanged. I bought an Apple phone, it got hanged. But obviously they do not know that they have bought duplicate phones. So it is very important to have an enforcement of trademark. And I think enforcement is very important because policies are everywhere. हर country almost हर एक के पास इंटेलेक्चुअल प्रॉपर्टी के रेजीम्स हैं, पॉलिसीज हैं, लॉज हैं, बट उसकी इन्फोर्समेंट भी उतनी ही जरूरी है और उतनी ही लाजमी है, क्योंकि अगर वो इन्फोर्समेंट नहीं होगी तो कोई भी किसी के भी प्रोडक्ट्स को अपना बना के पास ऑफ करता जाएगा और यूज करता जाएगा और उनकी गुडविल पे अपना प्रॉफिट करता रहेगा. So it creates the image of a product in the minds of the public, especially consumers or the prospective customers of a buyer. So एक image बन जाती है, जैसे हमने सोचा है कि obviously we are so eagerly waiting for the new iPhone. For example, now we are at iPhone 14. Now I know that if I see a phone and if it has 3 cameras underneath it and it has a bitten apple imprinted on the back of its side, then it is an Apple phone. So yes, it creates an image that, yeah, okay, this is an Apple phone. The trademark can be renewed for 10 years, by the way. And I forgot to tell you the temporal limitation of copyright, which was 60 years. And for the trademark, it is 10 years. So you get a trademark for 10 years with a subject to renewal. There are other unconventional trademarks also, which I would like to discuss, because personally, I'm a very big fan of fragrances. I like fragrances a lot. And I remember the first time my mother did a small type of shopping from duty free as we were coming from somewhere. And she bought a Chanel No. 5 perfume. I'm not just boasting, I'm just trying to give you an example. So that very perfume had gained such a distinctive aspect to it that it came under the purview of trademark protection under smell marks, which is protected by the USPTO, which is the United States Trademarks and Patent Office. So beat that, a smell can also be trademarked. There was also this example which was given to me by my mentor. A ball gave a fragrance of grass. So that ball was also given a trade. That smell was given the trademark protection because it was very distinctive. It was never been done before, and it actually gave the source of origin as Dunlop, which is, I think, a very big name in the industry. So yeah, this is how trademark and the nuances of trademarks follow. Chanel number 5, here it is. So now, what is like, what is the rationale if I ask you all कि मुझे एक ट्रेडमार्क चाहिए, आप बोलोगे क्यों भाई, ट्रेडमार्क क्यों चाहिए? ट्रेडमार्क इसीलिए चाहिए क्योंकि वो डिस्टिंक्टिव है बाकियों से, और जिसकी वजह से उसको एक लेवरेज मिल रहा है. सो बाय द वर्च्यू ऑफ दैट लेवरेज, I would articulate a product which will be different from the others prevalent in the market. So the distinctive trademarks are different from the other marks used to describe similar goods or services, ones which include a visual description of the type of goods or services, or recognized as identifying the source of the goods or services. Chanel recently registered its bottle number 5 fragrance as registered trademark in the US, as I discussed. So Chanel number 5, kudos to you. You got yourself a trademark because of being distinctively similar, very distinctive from the prevalent fragrances in the market. So yeah, this was one example, Chanel number 5. Now, a well-known trademark. Can anybody tell me what is a well-known trademark? I think by the looks of it and by the looks of the PowerPoint presentation, these two brands are notoriously famous. Can anybody tell me by just looking at it, what might be a well-known trademark? Anybody in the audience?
Louis Vuitton?
Yes, 100% Louis Vuitton, as it is in the slide. But apart from these, I discussed Rolex with you. That is also a well-known trademark. Apple is a well-known trademark. So what constitutes a mark as a well-known trademark? If the border, if the reputation is across the border, if the product or the goods have attained such amount of, sorry, I was prompted. Did anybody wanted to ask something? Okay, so anyways, so these products have a worldwide reputation and a worldwide goodwill. So when I talk about Hermes, as how it is pronounced in Paris, and Louis Vuitton, Rolex, Apple, Samsung, Starbucks, all of these companies and all of these and the trademarks of all of these companies are well-known trademarks because it is known by, and it is acquainted with a significant portion of the public who use such goods and services. So if I wear a Louis Vuitton belt, I would wear a Louis Vuitton belt, and I know the people who are going to look at it, they would know that their guest Pranav is wearing a Louis Vuitton belt. So yeah, that's a well-known trademark. Now I would just want to ask you all, or not just ask, I would just want to throw light on the concept of protection of trademark. So you can also have protection over a trademark even when it is not registered by a common law principle called passing off. But if at all my trademark is registered, it will have a sign of an R alphabet written, which is going to have a circle on the circumference of that R. So that says, we must have seen it on a lot of occasions that we see a registered symbol. That's when the company wants to tell that, okay, this trademark is a registered trademark. So this will be protected if there is any infringement. But if at all I have not registered my trademark, and still it can have a TM over it, and I can still defend my trademark by the common law principle of passing off. Can anybody tell me what is common law? Like if at all we have any law student in the seminar right now, can anybody tell me what's common law? Just to give you an example, Canada, India, UK, Australia, all of these countries are common law countries. So common law countries are basically countries, or common law is basically which is driven by judicial precedents or unwritten principles. For example, in 1847, if I have articulated this judgment that Quebec, being a province in Canada, cannot secede from the dominion of Canada. So that is the secession is a common law principle. The common law principle also transferred to India as well. So if at all Kashmir one day wakes up and says that, yeah, okay, I want to be a different country, but no, the secession is not possible because that's a common law principle that India also adheres to. So yeah, if at all you do not have your trademark registered, that's not an issue. You can still have it protected by passing out. So the two remedies that are available on infringing a trademark are passing off and infringement. So you can have a civil remedy as well as a criminal remedy. So yeah, deceptive similarity. A mark shall be deemed to be deceptively similar to another mark if it is so nearly if it so nearly resembles that other mark as to be likely deceive or to cause confusion. मैंने आप लोगों को एग्जांपल दिया था ब्लैकबेरी का और ब्लैक चेरी का, वैसे ही मैं बहुत पहले मैं whenever I've been raised in West Delhi, so there's this place, a very famous place called Karol Bagh, and whenever I used to go there, I used to see the first-hand copies of well-reputed shoes called like Adidas, Nike. They used to be called as Adibas or Niklo, and the sign used to be somewhat distorted and not a tick sign, and the Adidas sign had some more things to it. And all of these things I've been witnessing since childhood, because piracy is something which has been acting like a termite on the creation of authors in India. So piracy in India is exorbitantly high, as we can see. And I have with the help of a few, I found this meme where we can see the original shoes are at the top, Adidas, Adibas being the first copy, and the second being and the second being the second copy. So we can see the example. They're all deceptively similar. A person who is not as well read as we are, they would get confused. And the sight of this can cause confusion. If I see Adibas written and I'm not that well acquainted, or I'm not that well read that I should be knowing the difference between an original Adidas shoe or a duplicate Adidas shoe, then I would get confused. And just by that, by the virtue of that mere confusion, or by the deceptive similarity, the shopkeeper or the producer of that product which has done the piracy of Adidas shoes will reap the benefit of Adidas, because people will think that they are buying Adidas although they are not. So that is how deceptive similarity comes into play. Is this concept clear, everyone? I would assume that as an yes.
Yes,
Okay.
sir.
Yes, sir.
Sorry for the profanity, and I do not mean to hurt anybody's sentiments, but there was this landmark case again, which I cannot deny, but to put it in the slide. Playboy Enterprise Incorporated versus Bharat Malik. Playboy magazines. So there was this guy called Hugh Hefner. He created what Playboy is today. It was a magazine that dealt with a lot of things and was infamous for being symbols of women being objectified or something lascivious. So yeah, Playboy had attained that notoriety, and Bharat Malik. So he used the Playboy bunny. So this is a Playboy bunny in the slide, as we can see. It has a reputation across the globe. Anybody who sees the Playboy bunny knows that it is a Playboy thing. In fact, many songs, like a song which I can recall on the top of my head, which is an artist namely Nickelback had written this song called Rockstar. Even in that song, he mentions about a Playboy bunny. So a Playboy bunny has attained it is a well-known trademark, because it is not just the magazines that come with Playboy. There are perfumes, there are other merchandises. So this guy Bharat Malik, he uses his products and he imprints the Playboy bunny over his products. Now, the Playboy Enterprise Incorporation sends a cease and desist notice to Mr. Bharat Malik and asked not to use the Playboy bunny symbol because of the fact that it is trademarked by Playboy, and it is a well-known trademark, and Bharat Malik cannot reap the benefits out of the Playboy bunny. So yeah, just another case, just to make it more interesting, I had put Playboy. So yeah, Section 9 and Section 11 of the Trademarks and Merchandise Act are like super important if you are willing to give, or if you are willing to get into the course of intellectual property anytime soon, and if at all you want to have some knowledge about trademarks, then Section 9 and Section 11 and Section 10 as well, all of these sections are very important. Section 9 being absolute grounds of refusal. So what are the absolute grounds of refusal, if I may ask? एक लेमैन टर्म में भी मैं समझ सकता हूं कि एक ट्रेडमार्क को कब एक एसोसिएशन नहीं देगी रजिस्ट्रेशन, अगर मैं कोई ऑब्सीन चीज को ट्रेडमार्क कराना चाहूं, अगर if I have a product and its symbol is two people having fornication, so or coitus, so I cannot use that as a symbol because that is obscene. I cannot show two people in their intimate position or in a compromising position and use that as a symbol because it might get popular, it might get notoriously famous, but obviously it cannot get registered because of the moral fiber attached to it. Now, secondly, if at all my trademark is hurting any religious sentiments or sensitivities of any class or action, for example, sorry, I'm already putting up a disclaimer if I don't mean to hurt any sentimental values of anybody in the lecture. If I sell cigarettes by the name of Guru Nanak cigarettes, it will be shunned there and then because I am actually hurting the religious sentiments of Sikhs across the globe. Because even if we do not know that Sikhism is totally an antithesis of on the consumption of tobacco, but using a god's name for selling things like tobacco or alcohol has been an absolute ground of refusal. I cannot do that. I absolutely cannot do that. I cannot use the name of a goddess and put it on a liquor bottle and sell it out to people. I cannot do that. That's an absolute ground for refusal. And if my mark causes deception, for example, if I make if I have a lot of money and then decide to open a phone company tomorrow and I name it as Nokla, I may not get it registered because it might cause confusion to the people because there is already a brand which has already established a goodwill called Nokia. And Nokia are deceptively similar. It can also be, so this area comes under absolute grounds and relative grounds of refusal as well. So yeah, majorly these are the things which are the grounds for refusal. And obviously, if, last but not the least, if the mark lacks any distinctive character, then it becomes an absolute ground for refusal. If मेरा कोई प्रोडक्ट कोई बता ही नहीं रहा है, कोई डिस्टिंक्शन ही नहीं दिखा रहा है, कुछ ये प्रोडक्ट बाकियों की तरह ही है, और अगर कोई चीज एक ऐसी कोई पब्लिक डोमेन में आ जाती है, इतनी ज्यादा पब्लिक डोमेन में आ जाती है कि सबको ही पता है, तो मैं उस चीज को ट्रेडमार्क नहीं कर सकता, मैं उस चीज को रजिस्टर नहीं कर सकता. इफ इट हैज कम अंडर पब्लिसी ज्यूरिस, व्हिच इज द लैटिन वर्ड यूज्ड फॉर पब्लिक डोमेन, I cannot trademark that. And if at all have the mercy of God has been recited by a lot of Christians, I cannot trademark that because it is customary in the current language of many European languages. So they cannot give me a trademark protection over something which is already in the public domain. Now we head over to patents. So while starting the seminar, we had discussed that patents have their purview over an innovation. Trademark had its purview over a good or a service. Copyright was under the purview of an authorship of an artistic, musical, or dramatic, or cinematographic, or a sound recording. So now we know the difference, right? So people now in my seminar cannot make this mistake of using these three or these four terms synonymously. Please, patents, trademarks, and copyrights are very different concepts, and these should not be used synonymously under any circumstance. Now, I will tell you what precisely patent is, so that we know the difference now among the three. Why do I want a patent? So patent is on an innovation. So if, for example, back in the days, now we use Dolo and paracetamol like it's nothing. But back in the day when it was invented, or when penicillin was invented, or when insulin was invented, why would people want to get it patented? Because obviously I've invested so much of labor in it. I've invested so much of time in it. I've done research and development over it. So how can somebody just use my creation or my innovation and use it to their advantage? I should be getting my fruits for my labor. So yeah, Brufen at that point of time was invented, and it was also having the patent for 20 years, and obviously now it is in public domain. Anybody can make medicine out of Brufen by different names. Obviously, I cannot make a Brufen or a paracetamol named Crocin because it's already there, or Dolo because it's already there. But yeah, we know that the patent grants me the right for sale, the right to grant license to use, and the right to claim damages. But there are certain exceptions to it, and I'll come to that later. So the patent is an exclusive guaranteed by the government to the author to exclude the others from making, using, selling, importing an invention which is new and having that invention solution to a problem. So yeah, it obviously works on the same rationale as others, because I want to preclude others from making, using, or selling, importing my invention without my permission, or without my giving them an exclusive or a normal right. So that works on the same rationale as trademark and copyright. Now, this is the most important part of patent. So I want you all to have your utmost attention here. So what is the eligibility criteria for filing a patent? First is novelty. Second is non-obviousness. Third is industrial capability. Novelty is new. It has to be new, or it has to have an enhanced efficacy. Enhanced efficacy was a doctrine which was coined in a landmark judgment of the Supreme Court, and which obviously governs and perpetuates the concept of novelty, that it need not necessarily be absolutely new, but it should have such elements which makes it a concept newer to the previous one. Novelty. So as going by the slide, this means that your invention must not have been made public, not even by yourself. It should be new. Only then you can claim a patent over it. It should be non-obvious. The invention must be a significant improvement to the previous one. Mere change in the technology will not give the right of the patent to the inventor. अब अगर मैं एक machine है जो सबने जिम में देखी होगी, if somebody is into gymming, it is called seated rowing, and there's a rotating turbine attached in the front of the machine which can also wash clothes. So now, if in that machine of seated rowing I add a bicep workout, so that is not something which is very new, or which is a significant improvement. It is just something that I've added very frivolously. So that cannot be an ambit of patentability. So it has to be non-obvious. It cannot be obvious. It cannot be obvious. Now the third part is industrial applicability. The invention must be useful in a bona fide manner, meaning thereby, just give me a moment. Just give me a moment. Yeah, I'm so sorry. I had some disturbance. So yeah, the third part is industrial applicability. The invention must be useful in a bona fide manner, meaning that thereby that the invention must not be solely used in illegal work, or it should be useful to the world in a bona fide manner. So now things that cannot be patented are, obviously, I cannot patent a natural phenomena. I cannot patent the sunrise. I cannot patent an abstract idea. I cannot patent a law of nature. For example, a law of gravity cannot be patented because it is a law of it is a law of nature. Even though I can use gravity for my own use, but I cannot patent it because it is a law of nature. Physical phenomena or abstract ideas, all of these are precluded from patentability. Section 3 and Section 4 are the main sections for patents, with the things that can be patented and the things that cannot be patented. So now there's this landmark case for patents, and it also includes compulsory licensing, which acts as an exception to the temporal limitation of 20 years, which is given to the innovator of the patent. That before 20 years, nobody can use their invention, but this is a case which tells that yes, you can. So Bayer Foundation is a very big company. It is a very big pharma company. It has reputation all across the globe. It made this drug called Nexavar. So it basically dealt with kidney cancer and another cancer. It was basically a medicine which was very expensive. Now, Natco Pharma Limited, as brainies as us Indians are, we created a cheaper version of this medicine, substantially cheaper. If I give you an example, the Bayer Foundation medicine might be to the tunes of 1.5 lakh rupees of for one session, but Natco did it for just say about 2,000 rupees. So there's an exorbitant discrepancy between the prices. So Bayer Foundation obviously moved to the judiciary, asking the Natco Pharma Limited to stop the production. But that's when Supreme Court coined out the concept of public policy, because at that time, at that point of time, the cancer cases were growing so much, and obviously, just for the sake of public safety, a compulsory license was granted to to NATO to make the Bayer corporations Nexavar, and that is an example for an exception for the 20 years temporal limitation. क्योंकि 20 साल से पहले ही मुझे अपना innovation देना पड़ा, पब्लिक के लिए वो बहुत important था, तो इसीलिए वो 20 साल का एक एक्सेप्शन बन गया. और सुप्रीम कोर्ट ने बोला कि जब लार्जर गुड देखा जा रहा है तो लोगों का भला हो रहा है इसमें, तो इस चीज को मद्देनजर रखते हुए हम कंपल्सरी लाइसेंस इशू करते हैं नाटको को. सो दिस इज आल्सो अ लैंडमार्क व्हिच वाज टॉट टू मी. नाउ जस्ट टू हैव a difference between three. Copyright, it is on books, lectures, dramatic, musical works, cinematographic film, drawing, paintings, lectures. Then trademark subsists on a mark, logo, slogan, shapes, colors, sounds, gestures, animations, holograms, etc. Like Pepsi had this Dil Mange More. This was also a case. I will write it down on the chat, all the landmark cases for all the law students. So yeah, Ye Dil Mange More was a Pepsi slogan, and this was also a landmark case, and I'll write that down for you guys as well. And then patent, it has to be novel, original, and it has to have an innovative step. And yeah, so just you can have a bird's view of the difference between the three. So the validity is for 10 years for trademark. The validity is for 60 years for the copyright holder. And then just as we know the difference now, I think we cannot use them synonymously. GI. Okay, this is something which I believe that all of us are very acquainted with, because India is one of the front runners in getting their GI tags done and protected. Can anybody tell me an example of GI, as it was already spoken about, because we are moving on to the last part of the slides. I'm so sorry I've taken so much time, but now we're just about to end the slides. But before that, can anybody tell me an example of a GI tag? It need not necessarily be in India. It can be from anywhere. Anybody?
Sir, like Darjeeling tea,
Perfect. Wonderful. Who was that? May I have the name, please?
Jaya Sharma, sir.
Oh, yes, perfect. Jaya, that was a very, very well and a very good example for geographical indication. So what is geographical indication? As the name suggests, indication of geography. So it tells where the product has taken its inception from. So GI tag is a sign which is used on a product to have a specific geographical origin, and it possesses that quality or that reputation or those characteristics that are essentially attributable to that place of origin. Now, चाय बहुत सारे लोग बनाते हैं, चाइना भी बनाता है चाय, लंदन भी, मतलब यूके भी बनाता है चाय, इंडिया भी बनाता है चाय, बट दार्जिलिंग की चाय को क्यों जीआई टैग मिला? Because the soil, the way of irrigation, the way of agricultural method used in cultivation of Darjeeling tea is such that it adds certain attributes which makes it a very distinguished product from the others, getting under the purview of GI. So वो दार्जिलिंग टी के अंदर अरोमा, वो स्पाइसेस, वो सॉइल और उस क्लाइमेटिक कंडीशंस की वजह से वो चाय का टेस्ट ऐसा है कि उसको वो जीआई टैग मिला है. The main purpose of GI tag is to protect and promote products originating from a particular region, which have certain unique characteristics and prevent the misuse of the name and the reputation of these products. I'm so sorry. There are some examples. The black teas of Darjeeling, as we all discussed, and which was given by Jaya, wonderful. Champagne, guys, I'm so sorry I'm using the example of alcohol right here, but geographical indication has a major chunk of interception with alcohol. So I'll just discuss the alcohols with you. I think this might be of some interest for some of us here. Parmigiano Reggiano, Parmesan cheese, as we say. So that cheese originates from the Parmigiano Reggiano, Parma region of Italy. That is why it is called Parmigiano Reggiano. It has certain characteristics which are very unique to that cheese. That is why it has the GI tag. Basmati rice, Kashmiri saffron, Kanjivaram silk. All of these examples are of GI. Now, I would like to give you an example. Now, the modes of examples will be on the lines of alcohol. So, what is the difference between champagne and a wine? Actually, champagne is also a wine. It is a sparkling white wine. But if that white wine is bottled in the southern area of France, there's a place called Champagne in southern France. So if that white wine bottle is bottled and made in that region of France, it will be called as champagne, or else it will be sold under a white wine concept. What is the difference between Scotch and a whiskey? Actually, they both are the same. But if a whiskey is produced and sold by in Scotland, then it will be called as a Scotch. There was this Indian liquor company called Peter Scott. The Scotch Whisky Association sued them because Scott obviously tells them that the origin lies from Scotland, and obviously it must have the characteristics of Scotland Scotch. So that is how it was struck down, and nobody can sell Scotch apart from Scotland. Another example is of tequila. So blue agave plants, these are the plants which grow on volcanic areas, and Mexico is a volcanic area. The blue agave plants only grow in Mexico region. So the permission and the right to make tequila only stands with Mexico. There's no other place in the world that can make tequila but Mexico. Similarly, cognac and brandy. Cognac is also a brandy, but cognac is also a place in France. which makes that brandy and which gives a different characteristic to that brand. And towards the end of the slide, I would like to just briefly discuss trade secrets. Trade secrets are basically a set of information which is confidential and gives a leverage to the product over the other competitors. Coca-Cola, since 1981, it is a very big example of a trade secret because the formula still lies in Atlanta. There's like very less people know, like handful of people know the formula of Pepsi because it comes in concentrated forms and it is bottled under different procedures. It nobody can make Pepsi. Nobody can make Coca-Cola because the formula is in Atlanta, US. It is a trade secret. Another example is KFC. The KFC, we all know, we must have heard the name of KFC. So the 11 secret herbs and spices are still kept under a vault by Colonel Sanders somewhere in Kentucky. Google search algorithm, it is so efficient that they have made it a trade secret, and history gives, and we all know the potential of Google, and we all know the pinnacle Google has achieved. Like nobody can give a better search engine than Google. So the search algorithm is also a trade secret. Then McDonald's sauce, WD-40, all of these things are a part of trade secrets. So these formulas are very confidential and very less people know about this. That is why it gives them leverage over other products and other producers. Yeah, I guess my time is just to wrap it up. Blockchain is an emerging concept, and just for the researchers in the dais today, I would like to tell that I think IP and blockchain technology, like cryptocurrency and everything, they are of an emerging trend, and I think more research needs to be done. For example, NFTs, non-fungible tokens, they have a copyright mark and a trademark over them. So yeah, anybody who is willing to get into the field of IP should also have some or the other background knowledge about blockchain and how it has its Venn diagram intersection with intellectual property. So I guess get your ideas protected, get your expressions protected. That's all for the day for me. And that's my time with you guys. Thank you so much for bearing with me if I stretched it a little over time. And thank you all for the patience. And I believe and I hope that I get a chance to.
Thank you, sir. Thank you very much.
Thank you so much.
Thank you, sir, for your words of wisdom. Your lecture was self-explanatory. You have given the basic concepts of related with the IPR with the daily examples. So I think there will be no query because the lecture was very in simple language and up to the need of the students. Thank you, sir, once again. Dear participants, due to some emergency, our second resource person will be available after some time. So now we are going to start our technical session. For this technical session, first of all, I invite Dr. Blesh from M.D.S.D College for his paper presentation. Welcome, Dr. Blesh.
Hello, good afternoon, madam. Are you getting my voice? Hello? Hello, are you getting my voice, ma'am?
Yes, sir.
Okay.
Yes, sir. Yes, sir.
Okay.
Welcome, sir.
हाँ मैम, मुझे अलाउ करो स्क्रीन शेयर करने के लिए.
हाँ जी सर, आपको बना दिया हुआ है होस्ट?
No, not yet implemented. मैम मैं दो
सर कौन से नाम से? एक तो ब्लेश कुमार के नाम से, दूसरा कौन सा सर?
बालेश कुमार के नाम से.
हाँ जी सर. हाँ जी सर, देखिए अब
नॉट येट अलाउड मैम। मैं अपने लैपटॉप से जो ज्वाइन किया मैम उसको अलाउ को।
एक मिनट सर, देख रहे हैं जी।
किस नाम सर, आप किस नाम से हैं जी?
बालेश कुमार।
दोनों ही सर सेम नेम से हैं?
आप दोनों पे अलाउ कर दे, नहीं हाँ दोनों सेम नेम से होंगे। बालेश कुमार में लैपटॉप से ज्वाइन
ठीक
है।
है सर, हो गया सर, दोनों से कर दिया।
ओके ओके ओके। नहीं मैम, डिजेबल्ड है। मैं दूसरे से एग्जिट कर जाता हूँ। मैम मेरी स्क्रीन व्यू विजिबल है स्क्रीन?
हाँ जी सर, विजिबल है जी।
ओके 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 ओके, थैंक यू सो मच। गुड आफ्टरनून एवरीवन। It's my privilege to present my knowledge, basically not it is research paper. Actually, I'm not a person from the field of IPR, intellectual property right. Basically, I am a academician who has been assigned the responsibility, the duties to make awareness among the students about the intellectual property rights. So whatever knowledge I have, I would like to share it with you. I hope all of you will be useful for you, and you will also be able to learn something. However, जो हमारे अभी के मिस्टर राजपूत जो अभी आपके रिसोर्स पर्सन थे, उन्होंने बड़े ही डिटेल में जो है इसमें डिस्कस किया है। इंटेलेक्चुअल प्रॉपर्टी राइट्स के ऑलमोस्ट एवरी एस्पेक्ट्स को उन्होंने कवर किया है, लेकिन मैं एक अपनी जो प्रेजेंटेशन है वो वुमेन एंड इंटेलेक्चुअल प्रॉपर्टी राइट एक्सीलरेटिंग इनोवेशन एंड क्रिएटिविटी, उसके ऊपर एक ब्रीफ जो है अपनी प्रेजेंटेशन यहाँ पे देना चाहूंगा। यू मस्ट बी नोइंग कि विपो जो है वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी राइट और ऑर्गेनाइजेशन है जो, वो एवरी ईयर वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी डे सेलिब्रेट करता है, और वो रिसेंटली अभी 26 अप्रैल को हुआ था, जो हमने अपने इंस्टीट्यूशन में सेलिब्रेट किया था। और बीइंग आईपीआर एक्टिविटी कोऑर्डिनेटर मैंने जो है उसमें जो शेयर किया था वही चीजें मैं आपके साथ यहाँ पे शेयर करना चाहूंगा। तो before we come to the women and IP, we must know what the intellectual property is. बौद्धिक संपदा क्या है? वैसे तो काफी डिटेल में हमारे जो अभी के रिसोर्स पर्सन थे उन्होंने बताया है, पर मैं थोड़ा सा इसमें कहना चाहूंगा कि God has been very kind enough कि उसने हमारे को जो है सभी को जो है इंटेलेक्ट दिया है, माइंड दिया है, हमारे को विजडम दी है। हम जो है सोच सकते हैं, यदि हम सोच सकते हैं तो हमारे माइंड में कोई आइडिया आता है तो उसके ऊपर, जैसे हम अपने हाथों से यदि कोई चीज कमाते हैं, अर्न करते हैं, सिमिलरली यदि हमारे माइंड में कोई आइडिया हम कंसीव करते हैं तो उसका भी ओनरशिप, उसका भी रजिस्ट्रेशन करने का या उसको ओन करने का हमारा राइट है। और यदि उसको ओन करने का राइट है, उससे को कमर्शियलाइज करने का राइट भी है। उससे हम जो भी यदि उससे कोई उसको सेल कर सकते हैं, पर उसको जो है रेंट कर सकते हैं, उससे इनकम जनरेट कर सकते हैं, क्योंकि आज का जो एज है वो कमर्शियलाइजेशन की है। यदि हमारे पास कोई आइडिया है और उसको हम कमर्शियलाइज नहीं कर सकते, then it is of no use. So in the current scenario, commercialization is more important. So the IPR, the intellectual property rights, provide us such rights so that we can sell, we can create, we can generate income from our ideas. So and एक famous saying भी है कि idea rules the world. और जब आइडिया हमारे पास है तो आइडिया जो है वो क्रिएशंस को या हमारे इनोवेशंस को जो है को लीड, उसको प्रमोट करने में प्रमोट करता है। विद द हेल्प ऑफ आइडियाज वी कैन क्रिएट एंड इनोवेट वेरियस थिंग्स। And we all know there are two types of properties. One is tangible, other is intangible property. Tangible is basically the properties to which we can see. इनको हम मूर्त भी कह देते हैं, फिजिकल प्रॉपर्टीज भी कह देते हैं, to which we can see, we can touch. On the other hand, intangible assets are those assets जो कि जिनको हम देख नहीं सकते, but they are the creation of our mind. They are the knowledge of they are the ideas. और उनको different वे से हम उनको जो है डिफाइन करते हैं, जब उनको ट्रेडमार्क्स बोलते हैं, कहीं पे उसको पेटेंट बोलते हैं, कहीं पे उनको कॉपीराइट्स के अंडर आती हैं। तो वो चीजें हैं जो कि हम अपने माइंड से क्रिएट करते हैं और फिर वो हमारी प्रॉपर्टी के रूप में हम उनको ऑन कर सकते हैं। विपो के बारे में अभी उन्होंने बताया है, और ये उन्होंने जो डेफिनेशन मेनली जो है इंटेलेक्चुअल प्रॉपर्टी राइट्स के बारे में है कि क्रिएशन ऑफ द माइंड सच एज इन्वेंशंस, लिटरेरी एंड आर्टिस्टिक वर्क्स, डिजाइन एंड सिंबल्स, नेम एंड images used in the commerce. So the essence is intellectual property refers to the brand, an invention, design, or any other kind of creation that business or an individual has legal right over it. Just take a minute. और similarly, intellectual property rights जो हमारे exclusive rights हैं, जो हमें अलाउ करते हैं कि अपनी प्रॉपर्टी की हम जो कि फेयर वैल्यू डिसाइड करें, उसको सेल करें। और इसका दूसरा एक अदर पार्ट भी है कि इनको नेगेटिव राइट्स भी कहते हैं, क्योंकि हम भी ये दूसरे अदर पर्संस को डिनाई करते हैं, उनको अलाउ नहीं करते, उनको जो है उनको अपनी सेम वर्क के ऊपर जो है उनको अपनी, यदि मैंने कोई आइडिया कोई कंसीव किया है और मैंने उससे कोई चीज को इन्वेंट किया है, तो उनको जो है अलाउ नहीं करते, उनको परमिशन नहीं दी जा सकती। तो वो मेरे पास एक्सक्लूसिव राइट्स होते हैं, और ये मोनोपोली को कई बार जो है प्रमोट करता है, इसलिए इनको जो है नेगेटिव राइट्स भी कई बार कहते हैं कि ये राइट्स जो हैं इकोनॉमी के लिए कई बार नेगेटिव वे में भी काम करते हैं। यदि मेरे पास कोई आइडिया है और मैं उसको अलाउ नहीं कर रहा कि उस पे अदर पीपल में वर्क अपॉन इट। कॉपीराइट्स को हम जनरली जो है दो हिस्सों में बांटते हैं, एक इंटेलेक्चुअल प्रॉपर्टी राइट्स को, एक कॉपीराइट रिलेटेड राइट्स होते हैं, दूसरे इंडस्ट्रियल प्रॉपर्टी होती है। कॉपीराइट में जैसे उन्होंने बड़े डिटेल में बताया कि हमारी यदि कुछ ऑथर के लिटरेरी और आर्टिस्टिक वर्क्स होते हैं जो कि हमारे माइंड की क्रिएशन होती है, जो तो उनको हम अपने वे में प्रोटेक्ट कर सकते हैं, लेकिन इसकी कंडीशन है कि वो किसी न किसी वे में एक्सप्रेस होने चाहिए। सिंपली हमारे पास कोई आइडिया है या हमारे पास कोई वर्क है, तो यदि वो किसी भी फॉर्म में एक्सप्रेस नहीं हुआ है, देन इट कैन नॉट बी जो है इसका राइट नहीं ले सकते। लेकिन यदि हम इसको रजिस्टर भी नहीं कराते तो भी ये राइट हमारे पास होता है। और इंडस्ट्रियल प्रॉपर्टी के बारे में मेन चीजें उन्होंने बताई दी हैं। मैं थोड़ा सा इसमें जो है पेटेंट्स के बारे में यहाँ पे जरूर बताऊंगा। आइटम्स हैं जो पेटेंट्स के बारे में वैसे काफी डिटेल उन्होंने बताया है। पेटेंट्स बेसिकली इन्वेंशंस हैं, और इन्वेंशंस जो हैं जो कि नोवल हैं, न्यू हैं, और किसी भी किसी रिड्यूसिबल है टू टेंजिबल फॉर्म में, और यूज्ड इन टेंजिबल फॉर्म विदाउट टू मच स्किल्स और ingenuity that are valuable or useful to the society and that are conceived and discovered by the inventors। मतलब ये इसमें जो मेन चीज है कि नॉवल होनी चाहिए, इन्वेंशन जो है कि अपना न्यू आइडिया होना चाहिए, और इसका कोई इंडस्ट्रियल एप्लीकेशन होना चाहिए, सोसाइटी की किसी न किसी प्रॉब्लम को सोल्व करने में कैपेबल होना चाहिए, तभी हम इसको ले सकते हैं। और ये मैक्सिमम 20 ईयर्स के लिए मिल सकता है, और ये दूसरे लोगों को प्रिवेंट जो है अदर्स से प्रिवेंट करता है कि उसकी मैन्युफैक्चरिंग सेल्स के लिए। मैं ज्यादा इन पे चीजें पे ना जाता हूँ क्योंकि बहुत सारी चीजें यहाँ पे डिस्कस हो चुकी हैं। मैं सिंपली सीधा डायरेक्ट जो है इंडिया के बारे में जो मेरा मेन टॉपिक है उस पर आना चाहूंगा। इस जो है मैं ग्राफ के द्वारा आपको दिखाना चाहूंगा कि जो है इंडिया की पोजीशन क्या है ऑल ओवर द जो वर्ल्ड में जो पेटेंट फाइल्स किए जाते हैं, तो उसमें से उसका जो 2021 का डाटा है, तो उसमें हम देख पाएंगे कि चाइना इज एट द टॉप। और पेटेंट बेसिक ये जो पेटेंट्स फाइलिंग का डाटा है, पेटेंट्स जो फाइल होते हैं उसमें से, हालांकि सभी के सभी जितने पेटेंट फाइल होते हैं उसमें से डिपेंडिंग अपॉन डिफरेंट कंट्रीज 70% तक के जो है पेटेंट जो रिजेक्ट हो जाते हैं। लेकिन ये सिर्फ फाइलिंग का डाटा है, और फाइलिंग के बेसिस पे हम हम इससे देख सकते हैं कि चाइना के अंदर 15,85,663 पेटेंट फाइल हुए थे 2021 में, और इसके बाद यूएस में है जहां पे सिर्फ 5,91,000। मतलब जब डिफरेंस देखिएगा कि चाइना की जो इकोनॉमी जो ग्रो कर रही है, क्योंकि वो पेटेंट बेसिकली टेक्नोलॉजी इन्वेंशंस को जो मिलती है, तो हम देख सकते हैं कि इंडिया इसमें जो है साथ में 6ठे नंबर पर है। और डिफरेंस इतना ज्यादा है कि कहाँ 15,85,000 हैं और कहाँ इंडिया के सिर्फ 61,000 हैं। तो जितने ज्यादा आपके पास पेटेंट होंगे, जितनी इंडस्ट्रियल प्रॉपर्टी अपने पास किसी कंट्री के पास या किसी नेशन के पास होगी, तो उसकी इकोनॉमी उतना ही ग्रो करेगी, उतना ही रिच होगी। तो इसमें जो है चाइना एट द आज की डेट में जो है इसमें सबसे ज्यादा लीडिंग उस पे है। लेकिन इंडिया के ट्रेंड्स भी मैं इसमें क्या है थोड़ा आगे आपके साथ शेयर करूंगा। 2017 का डाटा है, तो इसमें देखेंगे कि हम जो 2017 में हमने भी हम जो है इसमें जो है बड़ी दूर थे, लेकिन उसमें उस टाइम का जो चाइना का था उन्होंने जो 13 लाख किए थे और हमने 46,000 किए थे, और जिसमें से 12,000 ही हमें मिले थे। मतलब ये कहेंगे कि 25% के करीब ही हमें सिर्फ अलाउ हुए थे। 75% तो एप्लीकेशंस मेयरली रिजेक्ट हो गई थी। ये भी जो है 2021-22 का डाटा है, जिसमें कि लेकिन ये दिखा रहा है कि ट्रेंड जो है ग्रोइंग है। जो पेटेंट हमने फाइलिंग का ट्रेंड है जो वो 2021 और 22 का मिला के इसमें दिखाया गया कि 66,000 हमने फाइल किए थे और 30,000 हमें मिले हैं। तो 50% की रेशियो हमने इसमें अचीव की है 2021-22 में, जो क्योंकि ग्रांटेड में और उसमें सेम इसको कंपेरिजन है फाइनेंशियल ईयर 2015 से लेके 2022 तक का। इसमें कब कब हमारे को क्या क्या जो है कहाँ कहाँ हमारी पोजीशन क्या इंडिया की है ये, तो हमने इसमें 66,000 में से 30,000 जो है 2021-22 में मिले हैं। अब मैं बात आता हूँ कि जो हम जो है जो मेरा टॉपिक है वुमेन एंड आईपी जो है एक्सीलरेटिंग इनोवेशन एंड क्रिएटिविटी। बेसिकली विपो जो है जैसा कि मैंने पहले भी बताया कि जो है वो वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी डे सेलिब्रेट करता है और उसका हर साल का एक थीम होता है। और फिर लास्ट ईयर इसका जो थीम था वो यूथ एंड आईपी था, और इस बार उन्होंने जो है वुमेन एंड आईपी को दिया है, क्योंकि हम सब जानते हैं कि 50% ऑफ द पॉपुलेशन वो विमेन है। और यदि हम 50% पॉपुलेशन को इनोवेशन से और यदि अपने जो है उनको इकोनॉमी से दूर रखेंगे तो किसी भी नेशन की या वर्ल्ड की किसी भी ग्रोथ पॉसिबल नहीं है। तो उन्होंने इसको डेडिकेट किया था विपो ने कि इसको जो थीम जो दिया था विमेन एंड आईपी दिया था, और हमने उस पर एक छोटा सा अवेयरनेस सेशन बच्चों के साथ किया था। उसकी स्लाइड से मैं आपके साथ शेयर कर रहा हूँ। वुमेन के बारे में जो उन्होंने डिफरेंट जो स्टडी हुई है, चाहे विपो की हुई है चाहे वो यूनाइटेड स्टेट पेटेंट ट्रेडमार्क ऑफिस की हुई है, तो उन्होंने बताया है कि जो वुमेन्स हैं दे आर सिग्निफिकेंटली अंडर रिप्रेजेंटेड। उनका जो कंट्रीब्यूशन है या उनका जो शेयर है दैट इज टू मच, मतलब बहुत बहुत ज्यादा कम है। और डिस्पाइट कि हम जो है बहुत सारे जो हमारे जो स्ट्रीम्स हैं जिनको हम स्टेम बोलते हैं, साइंस टेक्नोलॉजी इंजीनियरिंग मैथमेटिक्स बोलते हैं, इनमें पिछले काफी कुछ सालों में जो है इनमें इनरोलमेंट बढ़ा है। इसके बावजूद भी इसमें जो इनरोलमेंट बढ़ने के बावजूद भी जो है जो विमेन है उनका जो आईपी के अंदर जो शेयर है वो उतना नहीं हुआ है। और इसका मतलब ये जो है ह्यूज डिफरेंस है। वो डिफरेंस क्या है मैं आगे आपको दिखाना चाहूंगा। ये जो है वर्ल्ड के जो टॉप मोस्ट जो है का एक डाटा है जो दिया हुआ एक जो चार्ट है जो ग्राफ जो शो कर रहा है कि जो मोस्ट फीमेल जो इन्वेंटर्स है वर्ल्ड के अंदर जो से कंट्रीज हैं। तो इसमें आप देख रहे हैं इस जो है ग्राफ के थ्रू आप देखेंगे कि जो वर्ल्ड का पूरा जो इसमें जो है जो पेटेंट फाइल हुए थे 2021 में, उसमें से टोटल एवरेज जो है वर्ल्ड की वो 17% ऑफ द फीमेल इन्वेंटर्स थे। मतलब कि 83% जो थे वो मेल थे और फीमेल जो वुमेन जो थी उनका शेयर सिर्फ इसमें जो है 17% था। और इसमें भी जो हमारे जो मेन जो कंट्री था जो कि कैरेबियन कंट्री है क्यूबा की जो वहां पे जो पेटेंट फाइल हुए थे उनका 53% जो था वो फीमेल का था, दैट वाज इन टॉप। और यदि इसमें भी हम देखेंगे कि इसमें जो हमारे इवन डेवलप्ड कंट्री है यूएस एंड यूके, जर्मनी एंड जापान, वो भी जो हमारी जो वर्ल्ड की जो हमारा एक रेशो है जो एक एवरेज है उससे बिलो थे। हालांकि चाइना वगैरह थोड़ा सा उससे ऊपर रहा था। और इंडिया का तो इसमें जो है कहीं नाम भी नहीं है कि इंडिया की जो फीमेल इन्वेंटर्स हैं उनका कोई इतना ज्यादा कि उसमें उसका रैंक बहुत दूर होगा, क्योंकि जापान ही जो उसका जो 10% शेयर है वो 69 नंबर पे है। तो हमारा तो यदि इसमें 74 कंट्रीज में से हम तो इसमें काउंट ही नहीं है कहीं पे। और जो जिन फील्ड में यदि वुमेन्स की हम बात करें कि उन्होंने आईपी लिए हैं वो किस किस फील्ड में लिए हैं, उनका जो मेन जो एरिया रहा है वो बायोटेक्नोलॉजी रहा है। जो लाइफ साइंसेज का जो एरिया है उनके वुमेन का पार्टिसिपेशन उनमें ज्यादा रहा है। बायोटेक्नोलॉजी में 29.6%, सिमिलरली फूड केमिस्ट्री में 29 ये 30% के आसपास का जो एरिया रहा है जो वुमेन का पार्टिसिपेशन यदि आईपी में रहा है तो वो मोस्टली लाइफ साइंसेज में रहा है। और वी ऑल नो कि वुमेन जो है ऑल रीजन्स में जो है दे आर शेपिंग द वर्ल्ड थ्रू देयर इमेजिनेशन, इंजेन्युइटी एंड हार्ड वर्क। तो हम ये कहीं पे ये नहीं कह सकते कि उनके अंदर जो है टैलेंट की कमी है या इंटेलेक्ट की कमी है, लेकिन जो हमारी असली चीज है कि उनको इक्वल अपॉर्चुनिटी की कमी है, उनको इक्वल अपॉर्चुनिटी नहीं मिल पाती। और यदि हम वुमेन जो है हर एरिया में चाहे वो जो है they are driving scientific breakthrough, setting new creative trends, building business and transforming our worlds. लेकिन जो उनका जो बेसिकली जो है inclusive जो women innovation creativity business are inclusive and embrace new ideas and perspective. So यदि वो उनका participation बढ़ेगा तो we all will be benefited. और half of the यदि हम global population को यदि उससे बाहर कर देंगे तो जो inclusive growth is not possible. तो basically इसके थ्रू मैं यही कहना चाह रहा था. और आप दूसरी जो बात इसके थ्रू हम कहना चाह रहे हैं वो यही है कि बहुत कम वीमेन इसमें जो पार्टिसिपेट कर रही हैं, और हम इसका एक सीधा सीधा कंक्लूजन ये है कि इफ द वुमेन लूज we all will lose out. So the purpose of the जो ऑब्जेक्टिव था जो विपो का, इसको जो वीमेन एंड आईपी को जो डेडिकेट करने का बेसिकली यही था कि ताकि हम वीमेन को सेंसिटाइज कर सकें, उनके अंदर अवेयरनेस क्रिएट कर सके, उनको और अपॉर्चुनिटी प्रोवाइड कर सके ताकि वो ज्यादा से ज्यादा जो है इंटेलेक्चुअल प्रॉपर्टी में या कह लीजिएगा इनोवेशन में पार्टिसिपेट कर सकें. अब ये कुछ एक जो है स्टोरीज हैं जो कि खासकर ऐसे वीमेन एंटरप्रेन्योर्स हैं जिन्होंने कि अपना जो है जिनका की जो कि लीडिंग है, जो कि हमारे को मोटिवेट कर सकती हैं, जो हमारे को आगे बढ़ने के लिए प्रेरित कर सकती हैं. उनमें से एक नाम ये आयशा बोवे का है. ये स्टोरी जो है विपो ने अपनी साइट पे डाली है, विपो की मैगजीन्स के थ्रू उन्होंने इसमें डाला है, इनको स्पेस दिया है क्योंकि जो इस साल का जो हमारा थीम था वो वीमेन एंड आईपी था, तो उन्होंने उसको दिया है. बेसिकली ये रॉकेट साइंटिस्ट जो रही है जो आयशा बोवे, और आयशा बोवे को जो है इसका जो ब्लू ओरिजिन एक मिशन है जो कि स्पेस में जो कमर्शियल जो है ट्रैवलिंग कराता है, कह लीजिए जो कमर्शियल व्हीकल्स लॉन्च करता है, तो उसमें इसका टिकट कंफर्म हुआ है. और ये फर्स्ट ब्लैक लेडी है जो कि आशा बोवे है. और बेसिकली ये साइंटिस्ट जो है स्पेस साइंटिस्ट रही है, लेकिन लेटर ऑन शिफ्टेड हरसेल्फ, वो अपने एंटरप्रेन्योरशिप में शिफ्ट किया है. और वो जो है अमेरिका की जो टॉप जो टू सक्सेसफुल बिजनेसेज हैं उनकी वो जो है सीईओ कह लीजिएगा या उनकी डेवलपर एस्टेब्लिश करने वाली कह लीजिएगा, उसमें एक स्टेम बोर्ड के नाम से है और दूसरा लिंगो के नाम से है. दोनों की दोनों जो है एक फास्टेस्ट ग्रोइंग कंपनीज है अमेरिका की, दूसरी एजुकेशनल टेक्नोलॉजी से रिलेटेड है. और बोवे जो है वो जैसे मैंने पहले बताया है कि वो जो है फर्स्ट ब्लैक वुमेन है जो कि कंफर्म हो गया जिसको कि स्पेस में ट्रेवल करना है. और वो वुमेन्स को जो खास करके फीमेल्स को जो है वो मोटिवेट करती हैं कि आप साइंस, टेक्नोलॉजी, इंजीनियरिंग एंड मैथमेटिक्स के फील्ड में आइएगा. उनको इंस्पायर करती है और उनको परस्यू करने के लिए उनकी वो एडवोकेसी करती है. इसमें जो है इंडिया के नाम भी काफी कुछ ऐसे इन्वेंटर्स हैं, ऐसे जो कि जिन्होंने इनोवेटर्स हैं, जिन्होंने कुछ अपने फील्ड में काम किया है, उन लोगों को भी जो है उन इंडियंस का नाम भी, उसमें से एक नाम कविता शुक्ला का है. और कविता शुक्ला क्वाइट यंग है. मेरी स्क्रीन में थोड़ा सा मुझे दिखने में कुछ स्क्रीन, हाँ, कविता शुक्ला जो है वो यूएस के 4 पेटेंट उसके पास हैं. और उनमें से जो है बाइनोमियल इंडेक्स डिजाइन है जो कि लाइफ टू इम्प्रूव द लाइफ अवार्ड द वर्ल्ड का लार्जेस्ट प्राइज है फॉर डिजाइन हर प्रोडक्ट यूज्ड बाय द फार्मर एंड फैमिलाइज अक्रॉस द ग्लोबल. बेसिकली क्या है कि जो कविता शुक्ला है ये जर्मन की, इसके जो इंडियन पेरेंट्स हैं, शी वाज बोर्न इन जर्मन. और एक बार उसने इंडिया में अपने जो है ग्रैंड पेरेंट्स के यहाँ पे जो है विजिट किया. और ग्रैंड पेरेंट्स के यहाँ विजिट करने के बाद उसने पाया कि उसको जो पीने के लिए जो पानी मिला वो पानी जो है गंदा था, कंटेमिनेटेड वाटर था, और जिससे वो बीमार हो सकती थी. लेकिन जो उसकी नानी थी, उसकी नानी ने जो है उसको देखा कि उसने कुछ उसको ऐसी कुछ होम रेमेडीज या अपनी किचन से कुछ ऐसी चीजें दी जिससे कि वो बीमार होने से बच गई. तो उसके मन में जब आइडिया आया कि यदि कुछ हमारे पास ऐसी चीजें हैं जिनसे कि हम फूड को खराब होने से बचाया जा सकता है, तो उसने जो है एक अपनी कंपनी लॉन्च की फ्रेश ग्लो के नाम से. और वो फ्रेश ग्लो आज की डेट में जो है एक कंपनी है जो कि हमारी जो हमारे फूड्स हैं उनको जो है खराब होने से बचाती है. और उसमें उसको काफी सारे पेटेंट उसमें उसको मिले हैं. और वो आज की डेट में, और जब ये इसके बारे में एक चीज और मैं बताना चाहूंगा, कविता शुक्ला जब जो मैट्रिक किया था उस टाइम इसके पास 2 जो है अपने पेटेंट्स थे. तो कविता शुक्ला उनमें से एक ऐसे इनोवेटर्स में से है जिसने कि इसमें जो है कि अपनी बहुत क्वाइट यंग एज में ही इसमें जो है उन्होंने काम किया और अब जो है कुछ अचीव अपने मुकाम को हासिल किया है. और अब उसकी जो सोच बेसिकली ये थी कि हमारे जो फार्मर्स हैं वो जो इतना अमाउंट, इतना कम से कम जो है हमारा अनाज तो ग्रो कर लेते हैं कि पूरा संसार उसको, पूरा जो वर्ल्ड पे जो हमारे ह्यूमंस हैं वो खा सकते हैं, भूखे ना रहें। लेकिन उसने कहा कि 800 मिलियन पीपल्स अभी भी आज के अंदर वर्ल्ड के अंदर ऐसे हैं जिनको खाना नहीं मिलता, और यदि मैं खाने को खराब होने से बचा सकती हूँ तो ये हमारी जो है एक बहुत बड़ी अचीवमेंट होगी, ह्यूमैनिटी के लिए एक सर्विस भी होगी। तो उसने इस पे काम किया, और अब वो जो है अपनी इस नॉलेज को जो है तो यूज कर रही है टू प्रिवेंट फूड स्पॉइलेज एंड रिलीव हंगर अराउंड द वर्ल्ड। Our story of simple beginnings, innovation and empowerment has the subject of a short film by director Bryce Dallas Howard. Similarly, एक कैनेडियन वुमेन है डॉक्टर नैन्सी मायो के नाम से, और उसने क्या किया है कि कई बार हम सोचते हैं कि अब तो मेरी एज हो गई, अब मैं क्या करूं। वो कैनेडियन जो नैन्सी मायो थी, उसने लेट 60s में अपना एंटरप्रेन्योर को सेटअप किया, और उसने हम एक ऐसा जो है एक डिवाइस, एक जो है एक सूट डिवाइस किया जो कि पार्किंसन के जो मरीज होते हैं, जो ऐसे पेशेंट्स होते हैं जो कि चल नहीं पाते, जिनकी बॉडी सपोर्ट नहीं करती उनको चलने हिलने में। तो उसने लेट 60s में जो है बेसिकली वो एकेडमिशियन थी, और देन उसको उसमें जो है एंटरप्रेन्योरशिप में शिफ्ट किया, और एक ऐसी उसने वो एक सूट डिवाइस किया जिसकी हेल्प से जो है कि वो पार्किंसन के जो पेशेंट्स हैं उनको एक सपोर्ट प्रोवाइड करता है। ये जो है मतलब वॉकिंग शू टाइप था, जो किसने जो है जिसकी हेल्प से वो जो है उन्होंने काफी लोगों की जो जिंदगी में जो है उनकी थोड़ा जीने में उनका आराम इसकी हेल्प से आया है। तो ये जो है नैन्सी मायो का नाम काफी फेमस जो है वहां पे उसमें है। मजूमदार शाह के बारे में ज्यादा बताने की जरूरत नहीं है। इंडिया की है, चेयरमैन ऑफ चेयरमैन एंड एमडी ऑफ बाइकॉन ग्रुप ऑफ इन बेंगलोर में है, और उसको द बायोटेक क्वीन के नाम से जाना जाता है। इंडिया की फर्स्ट लेडी है जो बायोटेक में, जिन्होंने की मदर ऑफ जो है इन्वेंशन भी कहा जाता है बायोटेक के फील्ड में। और जब उनकी कंपनी 2004 में जब लॉन्च हुई थी, और इट वाज द सेकंड कंपनी ओवर टू क्रॉस द US $1 बिलियन जो है डॉलर जो है मार्क, इट्स फर्स्ट डे ऑफ लिस्टिंग ऑन द स्टॉक एक्सचेंज। तो इन्होंने ऐसे एक दिन की जब स्टॉक मार्केट में जब इनके एक्सचेंज में जब इनका लिस्ट हुआ था, फर्स्ट डे में ही इन्होंने एक जो है $1 बिलियन के जो है उसको टारगेट को अचीव किया था। तो इस तरह से ऐसी बहुत सारी जो है स्टोरीज हैं फ्रॉम इंडिया एज वेल एज फ्रॉम अब्रॉड, जो कि वुमेन एंटरप्रेन्योर्स हैं, जो कि आगे आ रही हैं और जिन्होंने अपना एक नाम उसमें बनाया है। तो ऐसी बात नहीं है कि जो फीमेल्स हैं उनमें कोई जो टैलेंट की कमी है, इंटेलेक्ट की कमी है, बट जो बात है कि इक्वल अपॉर्चुनिटी की है। तो ऐसे ही वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी डे के उसमें जो है उसमें ओकेजन पे उन्होंने एक गैलरी एस्टेब्लिश की थी, विपो ने अभी भी की हुई है, जिसमें कि वो सेलिब्रेट कर रहे थे इनोवेटिव एंड क्रिएटिव एंटरप्राइजिंग वुमेन अराउंड द वर्ल्ड। और ऐसे जो है कि ऐसी लोगों को फीचर करना था, इसका जो ऑब्जेक्टिव था, जो क्योंकि अराउंड द वर्ल्ड वो आर फोर्जिंग न्यू होरिजन विद देयर ग्राउंड ब्रेकिंग आइडियाज। तो इसमें जो है काफी सारे हंड्रेड्स में जो है इसमें नॉमिनेशंस आए थे, उसमें देख के बड़ा अच्छा लगा। इसमें जो है इंडिया का जो इसके अंदर जो है पार्टिसिपेशन था वो एक रेस्पेक्टेबल है। 15 वुमेन फ्रॉम इंडिया उनके नॉमिनेशन इसमें एक्सेप्ट हुए थे, और जिसमें से जो है 6 इनोवेटर्स हैं, एक एंटरप्रेन्योर है और 8 IP प्रोफेशनल्स हैं। डिटेल्स उनकी एक फोटो में आपके साथ यहाँ पे मैंने शेयर करने की कोशिश की है। इनकी जो एक कह लीजिएगा इनका एक प्रोफाइल जो है वो अपनी साइट पे उसने जो है विपो ने डाली हुई है। इसमें अर्चना चुग और मंजू चौधरी, ये बेसिकली लाइफ साइंसेज के फील्ड से हैं। सिमिलरली डॉक्टर सुमिता निर्की है, चेरी भार्गवा है, इंजीनियरिंग के फील्ड से है, दीप्ति पाटिल है, इंजीनियरिंग से है, और अंकिता अरोड़ा है, हेल्थ से है, और एक प्रियंका मलिक जो है ये जो फैशन डिजाइन की उससे फेमस है, उस एरिया से हैं। और इनमें से कई लोग ऐसे हैं जिनके पास 100 से ज्यादा अपने पेटेंट्स हैं। तो ये अपने जो है इसमें इस फील्ड में काफी जो इन्होंने लैंडमार्क को अचीव किया है, तो इन लोगों के नाम वहां पे डाले हैं। इसमें से कुछ ऐसे ही IP प्रोफेशनल्स भी हैं जो कि IP के बारे में या तो अवेयरनेस क्रिएट करते हैं, या जैसे हमें कोई इंस्टीट्यूशंस में जो IP को कैसे फाइल करना है, और IP जो ग्रांटिंग टीम होती है जो उसके मेंबर होते हैं, तो ये ऐसे प्रोफेशनल्स हैं। और यहाँ पे मैं एक चीज और कहना चाहूंगा कि US का उसमें जो पार्टिसिपेशन था दैट वाज ओनली 8 वुमेन, और उनमें से भी एक पूजा भाटिया जो है वो US की है, लेकिन बेसिकली वो इंडियन ओरिजिन की है। तो हम इसमें ऐसा नहीं है कि इंडिया इसमें कहीं अब पीछे है, लेकिन जो ओवरऑल में जो है वो है उस रैंकिंग उस लेवल पे भी ओवरऑल फीमेल ही नहीं है, और इंडिया थोड़ा सा और पीछे है। और इसमें तो इसको प्रमोट करने के लिए इन्होंने कुछ सर्टेन जो है पॉलिसीज भी जो है इन्होंने गवर्नमेंट ने कुछ स्कीम भी निकाला है, ताकि हम जो गवर्नमेंट जो वीमेन एंटरप्रेन्योर्स हैं इनको प्रमोट कर सकें। तो इनमें जो है एक तो इंडिया ने 80% रिडक्शन किया है फीस में वुमेन लेड स्टार्टअप्स के लिए, एंटरप्रेन्योर्स के यदि कोई आता है तो उनकी जो पेटेंट फाइलिंग फीस है वो 80% तक रिड्यूस है। सिमिलरली जो है यूनाइटेड स्टेट पेटेंट एंड ट्रेडमार्क ऑफिस ने जो है वो फ्री लीगल असिस्टेंट प्रोवाइड करता है। और सिमिलरली जो है मैक्सिकन इंस्टीट्यूट इंडस्ट्री प्रोपरेटिव है, वो भी जो है वेरियस टाइप की रिसोर्सेज इंक्लूडिंग ट्रेनिंग एंड मेंटरिंग जो है उस वर्कशॉप वगैरह प्रोवाइड करता है। मैं जस्ट थोड़ी देर में ही जल्दी ही कंक्लूड करने को जा रहा हूँ, इतना मुझे लगता है कि मैंने ज्यादा टाइम ले लिया है। एक जो चीज है कि हमारा ये ग्लोबल इनोवेटिव इंडेक्स, इनोवेशन इंडेक्स हर साल जो रिलीज होता है 2022 का, तो पिछले यदि हम देखेंगे जो है 2015 से यदि 2022 तक की रैंकिंग देखें तो वहां पे उसमें जो है ह्यूज हमने एक बड़ी जो है जंप उसमें किया है। हम जो है 2015 में जो 40वें नंबर पे हुआ करते, 81 नंबर पे हुआ करते थे, अब 40वें नंबर पे है। तो ये प्रेजेंट गवर्नमेंट का इसको क्रेडिट जाता है कि उन्होंने इनोवेशंस को, स्टार्टअप्स को काफी प्रमोट किया। और ये हमारी केवल ना कोई इकोनॉमी को स्ट्रेंथन करने के लिए बल्कि वर्ल्ड के अंदर हमारी ओवरऑल इकोनॉमिक फील्ड में भी और टोटल जो हमारी जो एक इमेज कह लीजिए कि हमारा इंडिया का जो हमारी जो प्लेस है या इंडिया की जो रिकॉग्निशन है उसको इम्प्रूव करने में काफी इसमें किया है। तो आगे तो बहुत सारी चीजें जो कॉपीराइट वगैरह के बारे में बता गया, मैं अभी इनको इन पे फोकस ना करता हुआ तो मेरे ख्याल में जो मेरा टॉपिक था वो तो यहाँ पे कवर हो गया। और मैडम क्या मैं यहाँ पे फिनिश कर सकता हूँ, शुड आई कंटिन्यू फर्दर?
सर मेरा ख्याल है 5 मिनट में सर वाइंड अप कर दीजिए बस।
वैसे तो मैंने वाइंड अप इसमें कर ही दिया। हाँ, मैं थोड़ा सा है कि ये मैंने पहले भी कई बार किया, जब हम जो है कॉपीराइट का एक जो है इसमें इशू रहता है कॉपीराइट के बारे में, जैसे कि फेयर यूज के वगैरह के बारे में उन्होंने बताया। तो इसमें एक दो स्टोरीज हैं जो मैं थोड़ा सा आपके साथ इसमें जरूर डिस्कस करना चाहूंगा। पहले मैंने एक दो बार ये डिस्कस किया है, हो सकता है आपके यहाँ भी कोई पहले पार्टिसिपेंट्स इसमें कर गए हों, कि कॉपीराइट का जो इशू होता है कि जैसे कि मंकी सेल्फी का केस है जो कि कॉपीराइट का बड़ा जो इसमें चला कि क्या कॉपीराइट्स आदमियों के ही ह्यूमंस को होते हैं कि क्या जो है ये जो है एनिमल्स के भी हो सकते हैं। एक इसमें ऐसी स्टोरी है जो मंकी की सेल्फी का है, जिसमें कि ब्रिटिश फोटोग्राफर था डेविड स्लेटर, जो कि नेशनल पार्क्स में जो है वो एक बार जो ट्रैवल कर रहा था, उसने जो है एक मंकी के बड़े क्लोज एक फोटो जो है बड़ी उनकी एक नेचुरल फोटो लेना चाह रहा था। और उसने एक वहां पे एक ऐसा कैमरा लगाया था कि ताकि जो है एक नेचुरल फोटोग्राफ ले सके। और जो मंकी क्योंकि बड़े शाई होते हैं तो वो जब भी उनके पास कोई इस तरह की यदि उनका फोटो ले तो उनका नेचुरल जो इनका अपीयरेंस है वो बिगड़ जाए, तो उसने एक वहां पे इसको अवॉइड करने के लिए एक कैमरा फिक्स अप वहां पे किया था। और जब उसमें जो है बाय द मंकी आया और उसने कैमरे से जो उसको क्लिक किया और ये सेल्फी उसमें आ गई जो कि ऊपर दिखाया हुआ है। तो इसका बाद में जो है उन्होंने इसको एक मैगजीन के कवर पेज के लिए भेजा। और जब उन्होंने कहा कि इसको कवर पेज पे जब ये पब्लिश हो गई तो उन्होंने इसको कॉपीराइट के लिए जो है इसके लिए क्लेम किया। तो जो पैटा की जो है जो एथिकल जो पीपल फॉर एथिकल एंड ट्रीटमेंट ऑफ एनिमल्स है, उन्होंने इसको जो है क्लेम, उन्होंने कहा कि क्योंकि उन्होंने इस पे केस कर दिया। उन्होंने कहा कि ये क्योंकि मंकी की सेल्फी या मंकी की फोटो उसने खुद ली है और आपने नहीं ली, तो इस पर राइट भी मंकी का बनता है। तो काफी टाइम तक वहां पे ये केस चलता रहा और लास्टली जो है फिर ये केस क्योंकि ह्यूमन इंटरवेंशन इसमें नहीं थी, मंकी ने खुद अपनी ली थी, तो बाद में जो है फिर इनको जो है कोर्ट से बाहर इन्होंने सेटलमेंट किया। उन्होंने कहा कि जो इसका अपना बार में एक समझौता कह लीजिए कि उन्होंने एग्रीमेंट कर लिया कि जो इससे रेवेन्यू होगी 25% उसका जो है वो रॉयल्टी जो मिलेगी वो मंकी के उनके एनिमल के वेलफेयर के लिए, मंकी की सेंचुरी के लिए डोनेट कर दी जाएगी। तो इस तरह की बहुत सारी स्टोरीज हैं जिनको कि हम इसमें जो कर सकते हैं। तो बाकी एक ये ब्रांड्स के बारे में जहाँ ट्रेडमार्क की बात होती है तो वहाँ एक ब्रांड्स की जो बात होती है कि ब्रांड्स की एक वैल्यू होती है, रिकग्निशन होती है, क्रेडिबिलिटी होती है। यदि हम इस तरह की विदाउट ब्रांड की कोई चीज होगी तो नोबडी वुड लाइक टू टेक इट, क्योंकि इस पे एक डाउट जो है रहेगा कि इसकी कोई क्रेडिबिलिटी नहीं है। और सिमिलरली यदि एक ब्रांड के साथ आएगी तो एक ब्रांड की वैल्यू होती है, तो ब्रांड के नाम से वो चीजें बिकती हैं। हालांकि ब्रांड का क्वालिटी के साथ कोई लेन देन नहीं होता, लेकिन ये एक जो क्रेडिबिलिटी है, क्रेडिट है, उसका एक जो चीज रेपुटेशन जो होती है वो चीजें पे करती हैं। तो ये कुछ चीजें हैं जो कि आईपीआर में हो सकता है आपके रिसोर्स पर्सन कवर करें। तो मैं तो जो इसमें बेसिकली जो आईपी का और जो है विमेन का जो एरिया था उसको कवर करना चाहता था वो मैंने किया और आप लोगों ने मुझे सुना, थैंक यू सो मच। और एक मैं रिसेंटली अभी आपको हमारे कॉलेज में एक डॉक्टर शिखा है, उसने जो है एक पेटेंट रिसेंटली अवार्ड हुआ था, हमने उसको फेलिसिटेट किया था, उसका फोटो है। एंड विद दिस आई एम थैंक यू वेरी मच, आप लोगों ने मुझे बड़े पेशेंस के साथ सुना, थैंक यू सो मच।
थैंक यू सर, आपने बहुत ही कम समय में बहुत ही अच्छी प्रेजेंटेशन हमें दी। we are very thankful for that. Thank you, sir, once again. Our next participant, the speaker is Miss Jaya Sharma from GN Khalsa Institute of Technology and Management, Yamunanagar. Dr. Jaya.
Yes, ma'am. Ma'am, I would like to share my screen for PPT. Kindly allow me.
Okay, ma'am. Okay. Ma'am, you can share now.
Okay, ma'am. Is my screen visible?
No, ma'am.
Just a second, ma'am.
वैसे बंद ना करी मैं करनी वैसे
Just a second, ma'am. I'm facing some technical difficulty. Just a second. ये देखो मैंने शेयर्स अब मैं यहाँ पे स्क्रीन कर रही हूँ मैं बट ये आ रहा है स्टार्ट नाउ फिर कहाँ पे जाऊँ अच्छा अब मैम इज माय स्क्रीन अवेलेबल हेलो
No, ma'am.
No. Yes, ma'am. Available now.
Yes,
okay
ma'am.
ma'am
Now it is visible.
thank you ma'am good afternoon everyone so this is Jaya Sharma from Guru Nanak Khalsa Institute of Technology and Management Yamunanagar and the topic for my presentation is today a conceptual study about intellectual property rights and their considerable importance towards the business as it is very well explained by our resource person Mr. Pranav Rajput so I'm highly grateful to you but still as my paper is based on conceptual studies so I'm going to elaborate the same. As we all know that intellectual property refers to any original and exclusive creations that a human can include. It may be any artistic work, it may be any literary symbol, it may be any graphic, and even any scientific creation, you can say. So intellectual property rights, it basically refers to the rights that protect an inventor's or creator's creation, right? That is under the legal binding, which allow them to benefit from these creations in the long run. So along with this basics in our paper, I would like to focus on historical aspects, and I would also study about the various types of IPRs and how it is going to influence our day-to-day business domains. So at the core, we can say that to protect the creative expression of any human, any individual, we will follow the intellectual property rights. So if I talk about the basic objectives of my paper, the objective is to study about overview and history of the intellectual property rights. And my second objective is to know the significance of intellectual property rights towards business. And last but not the least, to have insights about the various types of intellectual property rights. So first of all, we can say that as we have started a meaning also, one can obtain this protection by leveraging our legal system, or you can say by choosing the right type of intellectual property right, be it trademark, it may be patent, it may be copyright. So with IPR, owners and creators, they have the liberty to gain the financial advantage considering their invention that generates the revenue for the business. So you can say that it primarily focus on the intangible creation of the human intellect. So today the countries across the globe, they use various terminologies for the project of their intellectual property. So consequently, there are various types of intellectual property rights that are made available in the various countries. We can have a look on the screen like patents, copyright, trademark, industrial designs, our trade secrets, and geographical indications and database also, which we have started. So you can say that in the ancient Rome, the basic intellectual property guidelines, the first legal and the adequate mention of modern day intellectual property, it can be backed in 17th and 18th century. If we would like to study about the history of IPRs, so we can say that we get this from the 17th and 18th century. And if we go back into the history, it started from the 500 BC. It first came into the existence when the Siberis that allows their basically the cooks of the restaurants, right? So at that time, they are allowed to generate, to dedicate the payment to their, patent to their new refinements. And for instance, you can say there are many complicated technologies such as trademarks, copyrights, they have came into the picture, but the basic idea of these IPs have remained the same. And the idea behind that was to encourage the people's creative thinking and allowing the inventors to relish the benefits of their original invention. So there are multiple mentions of IPR in our history, which makes it a fairly traditional concept. In 1474, Venice became one of the first country to issue a law to regulate the patent production and allow the individuals to gain exclusive rights over their inventions. And if we talk about the 19th century, there are many other countries that understand the importance of laying down the laws to regulate IPR and followed the footsteps of Venice by starting their own versions of IPR systems. So globally, you can say there are two different conventions that were basically signed to regulate the basis of IPR. That is Paris Convention for the protection of industrial property in 1883 and Berne Convention for the protection of literary and artistic work in 1886. And if we move towards the second objective, that is, we would like to understand the significance of intellectual property rights. So you can say that IP, it is a crucial component of any business, and it is very important for the success and survival of the business nowadays. So to excel into a business, you must proactively identify and adopt the appropriate IP strategies. It's a misconception basically that only lawyers they're going to possess the knowledge to manage and leverage IP assets. But in fact, it's imperative for a company to manage and strategize its IP assets effectively to establish into the market leader. So developing the necessary skills and expertise to manage these assets, it is of vital importance for having the sustainable competitiveness. In this regard, you can say that management professionals, they are better positioned to handle and monetize the intellectual property assets to generate revenue. So you can say that there is no secret that knowledge has become the basis for modern day enterprises. And it is very well said by the Henry Ford that 21st century is the century of knowledge, and the most real security mankind has in 21st century is the reservoir knowledge it has. So it's very safe to say that it is extremely crucial to protect reservoir, or you can say protect our exclusive legal bindings and ensuring the complete protection of human inventions. So moreover, IP, it provides a strong bargaining position in the business partnerships also. So you can say that IPs, it generates revenue for the business through different channels, which includes your licensing, franchising, and even selling protected products and services. Thus, when we are talking about mergers and new acquisitions and amalgamations, so protected IP assets, they are responsible for instantly boosting the overall value of the business. You can say that the world's top ranked organizations such as Apple, Microsoft, BlackBerry, they have developed the powerful revenue streams from their extensive IP portfolios. So therefore, you can say that maximizing benefits from a strong IP portfolio, which can lead to increased revenue, it can be done through the licensing streams. So there are ample of factors that have encouraged the business entities to perceive IP's assets and their significance in the scalability of a business. So these factors, it can include constant development, your globalization, your technical revolution, your increase in commercial activities, and undoubtedly enhancement in your knowledge. So you can say that in today's competitive landscape, it is very much imperative for a business to recognize the importance and necessity of the intellectual property assets, which serve as not only the exclusivity, but also lay down the foundation for the company's success. So it is very well said by the American businessman Mark Getty aptly, like intellectual property is the oil for the 21st century. So indeed, the wealthiest individuals a century ago, they amassed their fortunes by extracting and transporting the natural resources only. While today's richest individuals, they have made their fortunes by focusing on the intellectual properties. So therefore, it is the need of an hour that business must realize the crucial role of intellectual properties in their growth and survival. Next, moving on to the third objective of my paper, that is, what are the various types of intellectual property rights? There are various types like patents, trademarks, copyrights, trade secrets, industrial designs, and geographical indicators. Just have a glimpse of the same. Like patent, we all know that it is a government license that confers the sole right, or you can say to exclude others from making the same product, from making or selling the invention that is made by a particular person. So individuals or organizations seeking to protect their innovative products or processes approach the patent office. They provide details about their creation. They pay fee to secure patent production, and patents acts as an incentive for investing years of effort and resources into developing a new products and processes that is going to form an integral part of culture of innovation and growth. Now, there are various different types of patents, as we are seeing in our screen, that the patents are bifurcated into three types, that is utility patent, design patent, and plant patent. Utility patent, basically, it covers the functional aspects of an invention, like how it works, what it does, right? And if we talk about the design patent, it may be any new design to a bottle, design to an ornamental, such as with regards to its shape, with regards to its pattern, or you can say surface ornamentation, so which allows a unique appearance of an object that can be granted for any new, original, or particular design for an article manufacture. It is commonly used in industries such as fashion, furniture, and consumer products. And last but not least is the plant patents, as sir has quoted the sui generis system also. So it came into existence whenever the first of all the patent for the breeds of the plant has came into the existence. So these patents, these basically protects the distinct varieties of plants, which includes the hybrids and genetically modified plants. So they are granted to those who invents or discovers and asexually reproduces any distinct and new variety of plant other than any propagated plant or a plant that is found in any uncultivated state. So these are basically commonly used for the people who are engaged in agriculture, who are engaged in horticulture and landscaping. So you can say, like we have discussed about the utility patents, it deals with the functional aspects. Design patents deals with the aesthetic aspects of the invention, like shape, pattern, and plant patents, which give protection to the varieties of the plants. Now, moving on to the second category, that is your trademark. Trademark, it is any identifiable sign, symbol. It may be text, it may be number, it may be a phrase, it may be any shape, color, it may be a sound, like we have heard the sound of KBC, we have heard the sound of Vodafone, any packaging texture, or you can say that the primary, we can see on a screen that these are the various trademarks of the various good brands, right? So the primary purpose of a trademark is to help the customers easily identify the manufacturer or a service provider and associate it with certain quality and reputation. Like we know that in the soft drinks, Coca-Cola having a good brand, right? In the segment of burgers, we have M.D.S.D, we have HP in the media of laptops, Puma in the attire section, BBC in the news section. So simultaneously, when we are going to associate these with a particular quality and the reputation, right? Like Apple symbol is instantly recognizable as a product of Apple Incorporation. So these are some of the trademarks. A trademark, it must be registered with the trademark office of the country where it needs protection, and it must be associated with the relevant classes of the business. So you can say that a registered trademark, it provides legal protection to the owner, and it helps to build the brand reputation and goodwill. And moreover, it is very important to know that we can use the same trademark that can be registered for a different goods or services under different owners. For example, Nike Incorporation, it owns the trademark for Nike for shoes, clothing, and supporting equipment. Like Nike Corporation has registered the same mark for their hydraulic lifting jacks also, and other heavy machineries also. So you can, as I have told you, that there are various types of trademarks, like word trademark, service trademark, any mark that is used to identify the product or service, shape marks, that marks showing the shapes about the services of the company, logos, symbols, graphic marks, collective marks.
Excuse me, ma'am, please wind up your.
Okay, ma'am. Okay, ma'am. Okay. So after that, then moving on to the copyright. Copyright is basically given to the authors. They are writing something, their poems, stories, any article, any blogs, composers of any tunes, right? So there are endless number of items for which copyright. So it is very important to note that there may be a overlap between copyrights and IPR, and it is very crucial to understand the difference between the same. But it's very mandatory to get the copyrights for your written content. And if I talk about the trade secret, IPR law, trade secrets are of components. Trade secrets are basically dealings with your financial data, your techniques, the formulas you have invented, the patterns, the programs, the methodologies, any new procedure you have invented. So like, for example, KFC's secrets, herbs and spices recipes, the Coca-Cola secret soft drink formulas. So we are going to have trade secrets for the same. And last but not the least is our industrial design. So to maintain a competitive base in the market, unlike patents or trademarks, various industrial design protections, that does not cover the functional or technical features, but rather than they focus on the visual appearance. Industrial designs, like you can have on the screen, these things are having various industrial features, their appearance is different. They can be bifurcated on the basis of their fashion, consumer electronics items, furniture, automotive designs. And so to obtain the industrial license, creator of a design must file an application with the appropriation IPR office, and simultaneously they will share the drawings and photographs of the design. And last but not the least, that is the geographical indication. It is a symbol basically used for the product for its origination. The ownership of GI, it allows the authorized users to prevent any unauthorized use for the indication by a third party whose product does not meet the required standards. I also gave the example of Darjeeling tea, and there are few other examples like Kashmir's kava, Kolhapuri's slippers, and Bikaneri bhujia that arrives from the Bikaner. So these are going to be the GIs for a particular product, right? So that we could not produce according to the set standards of these law for which they have obtained. So in the conclusion, I can say that to manage the IPs and technical IPRs, it is a very complex task which involves various types of strategies, but it's no longer limited to the national perspective, and it depends on the market response and need also. So we should consider the different types of IPR, that they require unique treatments, planning, and engagement of people from different domains such as science, medicine, finance. So every industry, it is mandatory for them to develop IB policies, strategies, and if we want to give protection to our original work, so for that, it's very mandatory for us that we should get it copyright, we should get it trademark, or we should have a trade secret for the same. To very carefully we should register them. And but you can say that IPRs in nowadays, they remain a critical driver for the economic growth of any country. So thank you so much. That's all from my side.
Thank you, ma'am. Thank you very much.
Thank you, ma'am.
Our resource person, Dr. Vipin Saini, has joined. So first of all, I would like to give a brief introduction about Dr. Vipin Saini. So Dr. Vipin Saini is a well-known personality in the field of education and especially IPR. Professor Vipin Saini is working as Director, Research Administration Advisory Council, deemed to be University Mulana. Along with that, sir has worked as Dean and Principal MM School of Pharmacy, Director Research, Chairman Board of Studies, Vice Chancellor, MM University, Kumarhatti, Solan. So, sir has published more than 18 books and 25 chapters in different books. He has more than 150 national and international patents and copyrights filed. He has supervised 28 research scholars, PhD research scholars, and he has presented a number of papers in national and international conferences, seminars. He has worked as resource persons in many national, international conferences. So the list is never ending. So I have a profile of sir of more than 150 pages. So without taking much time, I invite Dr. Vipin Saini for his lecture. Please welcome, welcome, sir. Sir, Dr. Vipin Saini, are you there?
Please be with us. There is
Hello.
some technical glitch.
Hello, may I audible?
Yes, sir.
Uh, Very good afternoon to respected all. Myself, Dr. Vipin Sani. Hello,
Yes, sir. Yes, sir. You can continue, sir.
may I continue? May I continue?
हाँ जी sir. Yes, sir.
Thank you very much, respected Dr. Simaji, Honorable Principal Dr. Kiranji. And it is a great opportunity for me to deliver again the intellectual property right. Uh, Everyone, I think you know already the speakers speak about the intellectual property right. Intellectual property right has become the important in the face of changing the trade environment, like the global competition, high competition, high innovation risk, high investment in the research and development, and the production and marketing of each and every product. Suppose you are manufacturing the any such kind of electronic item, you are manufacturing the any pharmaceutical item, or even you are manufacturing the anything in the entire country. This is the great changing face trade environment. Competition is there. In order to maintain a continuous stream of the new ideas and the experimentation, intellectual property right is very important now in these days. This intellectual property right as a collective terms which includes the बौद्धिक संपदा. This is known as the बौद्धिक संपदा. Suppose आपने कोई घर बनाया अपना, उसका कोई डिजाइन नया बनाया है, उसका जो डिजाइन है आपके घर का वो आपकी प्रॉपर्टी है. आपने अपने आर्किटेक्चर साहब को, आपने अपने इंजीनियर साहब को पैसा दिया है, जो उसकी स्ट्रक्चर निकल के आएगी वो आपकी प्रॉपर्टी है. दिस इंक्लूड्स पेटेंट, कॉपीराइट, ट्रेडमार्क का this registered industrial design, geographical indication, and the protection of the undisclosed information. This intellectual property right is a property that arises from the human intellectual. It is a product of the human creations. आप जो भी चीज करते हैं, आपके दिमाग में कोई आइडिया आता है तो आप उस आइडिया को इम्प्लीमेंट करते हैं, वो आपकी संपत्ति है, ये किसी और की संपत्ति नहीं है. आप चाहे इंडिया में काम करते हैं, अब्रॉड काम करते हैं, जो चीज इनोवेशन आप काम करते हैं ये आपकी प्रॉपर्टी में बनी आएगी. दिस इंटेलेक्चुअल प्रॉपर्टी कंप्राइजेस ऑफ द टू थिंग्स. नंबर वन इज द लिटरेसी वर्क एंड द आर्टिस्टिक वर्क, एंड सेकंड वन इज द इंडस्ट्रियल प्रॉपर्टी. लिटरेसी वर्क, आप कुछ भी पेपर लिखते हैं, आप लोग कुछ भी अपना कविताएं लिखते हैं, कोई भी न्यूज आर्टिकल लिखते हैं, दिस इज आल्सो योर ओन प्रॉपर्टी. अगर कोई आप आर्टिस्टिक वर्क करते हैं, जैसे कोई डांस है, संगीत है, या कुछ गाना गाते हैं, ये भी आपकी प्रॉपर्टी है, किसी और की प्रॉपर्टी नहीं है, ये आप इसके राइट्स होते हैं. मैं एक यहाँ पे एग्जांपल देना चाहूंगा, बड़ी छोटी सी एग्जांपल है. आप डेली एफएम सुनते हैं, जब आप एफएम सुनते हैं, इसमें ओल्ड सॉन्ग भी आते हैं और न्यू सॉन्ग भी आते हैं काफी सारे. जो भी आपके ओल्ड सॉन्ग आते हैं, न्यू सॉन्ग आते हैं, इसकी रॉयल्टी, इसका जो पैसा होता है, ये एफएम वाली कंपनी को, चाहे वो 94.5 है या 98.3 है, इन सबको वो पैसा देना पड़ता है. किसको? जिसने सॉन्ग गाया था. सेकंड वन इज द इंडस्ट्रियल प्रॉपर्टी. सपोज यू आर डूइंग एनी सच काइंड ऑफ द न्यू और नोवेल इनोवेशन. आपके घर में मिक्सी है, आपने उसके अंदर मॉडिफिकेशन कर दिया, उसकी स्ट्रेंथ को बढ़ा दिया, दिस इज योर ओन प्रॉपर्टी. दिस लिटरेसी वर्क एंड द आर्टिस्टिक वर्क is include the books, book chapter, any design, any painting, any musical compositions, any play, any movie, radio, TV program, any performance done by the kids, and any such kind of the artistic work. This is come under the literacy and the artistic work. How it is protected? ये सारी की सारी जो कैटेगरी में आते हैं, इसको हम कहते हैं कॉपीराइट. आप अपना कॉपीराइट लिखें, कविता का लिखें, बुक्स चैप्टर का लिखें, सारी की सारी प्रॉपर्टी आपकी है, तो ये आपकी मानी जाएगी. भारत सरकार कहती है इसको माना जाएगा. सेकंड होती है इंडस्ट्रियल प्रॉपर्टी. दिस इंडस्ट्रियल प्रॉपर्टी विच इज डिस्क्राइब एज द फिजिकल मैटर दैट इज द प्रोडक्ट ऑफ एन आइडिया और द कंसेप्ट फॉर द कमर्शियल पर्पस. सपोज किसी ने अपने घर पे कोई नई इनोवेशन की, कुछ नया फूड आर्टिकल बनाया, नया फूड प्रोडक्ट बनाया आप लोगों ने, उसको हम प्रोटेक्ट कैसे करें कि वो सामने वाला या साथ वाले को इसको चुरा ना ले. कोई नोवेल इनोवेशन की, आपने कोई भी चीज, नई चीज बनाई, कोई नया टीवी बनाया, कोई नए टीवी का डिजाइन बनाया, ये कैसे प्रोटेक्ट करें, इस आइडिया को कैसे प्रोटेक्ट करें? दिस इज कम अंडर द कैटेगरी ऑफ द इंडस्ट्रियल प्रॉपर्टी. How it is protected? It is protected under the trademark, industrial design, trade secrets, layout design and the geographical indication. अब मैं आपको धीरे धीरे करके एक चीज बताऊंगा कि आपके पेटेंट क्या होते हैं, कॉपीराइट्स क्या होते हैं। कॉपीराइट का जैसे मैंने आपको बताया अभी कि कॉपीराइट के अंदर क्या है कि जितने भी अपने आर्टिस्टिक वर्क हैं सारे के सारे आपके कॉपीराइट के अंदर आएंगे। सेकंड वन है आपका ट्रेडमार्क का। सपोज किसी ने कोई कंपनी खोली, एग्जांपल है कि आपको मैं बता रहा हूँ कि जैसे बंसल बंसल फार्मास्यूटिकल, ये आपकी प्रॉपर्टी है, कोई और इसको ना चला ले, आप इसका ट्रेडमार्क का कराइए, नाम का आप अपना ट्रेडमार्क का करा सकते हैं। थर्ड थिंग होती है आपकी रजिस्टर्ड और इंडस्ट्रियल डिजाइन। सपोज आपके घर के अंदर कोई मॉडिफिकेशन किया, आप कहते हैं कि सामने वाला या साथ वाला कोई चुरा ना ले उस आइडियाज को, आप उसका भी करा सकते हैं प्रोटेक्शन आपका, बिकॉज ये आपकी प्रॉपर्टी है। इसको हम बोलते हैं जो रजिस्टर्ड डिजाइन। थर्ड फोर्थ थिंग होती है जियोग्राफिकल इंडिकेशन। जियोग्राफिकल इंडिकेशन क्या होते हैं कि जैसे अंबाला है, अंबाला का नाम क्यों फेमस है? अंबाला का नाम दो जगह से बहुत ज्यादा फेमस है। नंबर वन, यहाँ पे इंडस्ट्रियल इंस्ट्रूमेंट बहुत ज्यादा बनते हैं। सेकंड थिंग, यहाँ पे सबसे ज्यादा क्या होता है, मिक्सी का व्याप बहुत ज्यादा होता है। पूरे वर्ल्ड में जितनी मिक्सी बनती है जो अपन घर पे यूज करते हैं फॉर द कटिंग ऑफ एनी अनियन और एनी वेजिटेबल, ये वर्ल्ड में सबसे ज्यादा इसकी प्रोडक्शन सिर्फ अंबाला डिस्ट्रिक्ट में होती है। अगर इसको अपन कहें कि इसको मिक्सी के नाम से जाना जाए पूरे दुनिया में, तो हम इसका जियोग्राफिकल इंडिकेशन में रजिस्टर्ड करा सकते हैं नाम इसका, अंबाला डिस्ट्रिक्ट का। फिफ्थ होता है प्रोटेक्शन ऑफ अनडिस्क्लोज इंफॉर्मेशन। आपके घर पे रजिस्ट्री है, आपने अपने घर के अंदर कोई डॉक्यूमेंटेशन वर्क किया है, किसी टीचर ने या स्टूडेंट ने मिलकर कुछ नया अपना कुछ नोवल आर्टिस्टिक वर्क किया है या कुछ और अपना काम किया है, दिस कम अंडर द कैटेगरी ऑफ द योर खुद की संपत्ति। इसको इंग्लिश में क्या बोलते हैं अपने कि ऑन कॉन्फिडेंशियल डॉक्यूमेंट। ये कॉन्फिडेंशियल डॉक्यूमेंट आप चाहते हैं कि कोई और चुरा ना ले, इसकी लैंग्वेज को ना चुरा ले, इट्स कम अंडर द कैटेगरी ऑफ द पेटेंट इंफॉर्मेशन। अब आता है कि आपके पेटेंट क्या होते हैं, पेटेंट में कौन सी कैटेगरी आती है। पेटेंट दो तरह के होते हैं, एक होता है डिजाइन पेटेंट। डिजाइन पेटेंट होता है कि जैसे आपके घर में कुछ क्रॉकरी है, उसका कोई भी अमेंडमेंट कर दिया आप लोगों ने, तो डेट इज स्टार्ट एज अ डिजाइन। दूसरा होता है आपका कोई भी चीज जो प्रोसेस आपका बन रहा है, ऑलरेडी कोई भी चीज का प्रोसेस बनाया है आपने, रोटियां बनाने का कोई प्रोसेस बनाया है, अगर उसके अंदर आप मॉडिफिकेशन कर देते हैं, दैट इज नोन एज द प्रोसेस पेटेंट। मे ऑडिबल प्लीज? हेलो?
Yes, sir.
मे ऑडिबल प्लीज? नेक्स्ट वन इज द, जो आपका पेटेंट होता है और कॉपीराइट होता है, इसकी कितनी अवधि होती है कि लाइफ लॉन्ग कितना आपका रहेगा। जो पेटेंट होता है आपका, जिस दिन आपने फाइल किया उसके अंदर नैनो सेकेंड्स आते हैं, उस दिन आपके मिनट्स आते हैं, आवर्स आते हैं। ये 20 साल के लिए आपकी प्रॉपर्टी है, 20 साल तक आप इसको ले सकते हैं। अब 21वें साल अगर ये एक्सपायर होता है आपका, सपोज आपका 21वें साल आपकी प्रॉपर्टी एक्सपायर हो रही है, तो आपको भारत सरकार को ये फीस देनी पड़ेगी। आजकल क्या है कि भारत सरकार ने पहले जो फीस होती थी उसका इन्होंने बहुत ज्यादा कम कर दी है फीस अपनी गवर्नमेंट ने। पहले 4,000 रुपये फीस होती थी, अब इन्होंने 1,600 रुपये कर दी है फीस अपनी। कुछ गवर्नमेंट की ऐसी एजेंसीज हैं, अगर आप पेटेंट करवाना चाहते हैं तो ये फ्री ऑफ कॉस्ट भी करते हैं, जैसे टेक्नोलॉजी इंफॉर्मेशन फोरकास्टिंग, टैफेक और होता है, डिपार्टमेंट ऑफ साइंस एंड टेक्नोलॉजी होती है एक, वो वाला भी अपना पोर्शन है। तो ये सारे के सारे क्या चीजें होती हैं कि आप अपनी प्रॉपर्टी को प्रिजर्व कर सकते हैं। कॉपीराइट आपका लाइफ लॉन्ग के लिए होता है, 50 ईयर्स प्लस प्लस के लिए होता है, 50 ईयर प्लस प्लस के लिए आपका वो एलिजिबल होता है। अब भारत सरकार ने कहा है कि जो आपकी प्रॉपर्टीज हैं इसको अपन प्रिजर्व और ज्यादा इसको कैसे करें। सपोज आज आप इंडिया में काम कर रहे हैं, आपको फॉरेन में जाना है, कैसे काम करें अपन, फॉरेन के अंदर जाके कैसे काम करें। फॉरेन के अंदर भी हो सकता है, पहले आप भारत के अंदर आप इसको रजिस्टर्ड कर लीजिए, उसके बाद आप फॉरेन में किसी भी कंट्री, जैसे यूएस पेटेंट है, श्रीलंकन पेटेंट है, नेपालीज पेटेंट है, या और भी जगह पे, काफी जगह पे वर्ल्ड में सारी जगह पेटेंट होते हैं, जहां जहां अपना प्रोडक्ट आप लॉन्च करना चाह रहे हैं, तो ये सारे के सारे वहां पे ये एलिजिबल होते हैं। ट्रेडमार्क का, ट्रेडमार्क का जो होता है सिर्फ नाम का ही होता है। जैसे आपने कोई भी कंपनी का, अंबाला फार्मास्यूटिकल है, अंबाला प्रॉपर्टीज के नाम से है, या बंसल फार्मास्यूटिकल के नाम से है, जो नाम का होता है चीजें वो ट्रेडमार्क के अंदर अपनी रजिस्टर्ड होती हैं। ट्रेडमार्क का जो होता है आपका ये भी आपकी इसकी अवधि होती है 5 ईयर प्लस प्लस आप इसको गवर्नमेंट को फीस दे दें तो भारत सरकार इसकी कर सकती है। लास्टली नॉट लीस्ट, आपका सबसे बड़ी एक जो चीज बताने जा रहे हैं कि कॉपीराइट में क्या क्या कवर नहीं होता है। सबसे बड़ी लोगों के बीच में भूल रहती है कि कॉपीराइट के बीच में क्या कवर है क्या कवर नहीं है। आइडिया आइडिया को कॉपीराइट नहीं करा सकते, ये पेटेंट में जाएगा। कोई फैक्ट्स हैं, किसी भी चीज के कोई फैक्ट है, इसको अपन किस में जा सकते हैं, इसको अपन जा सकते हैं पेटेंट के अंदर। कोई रेसिपी है आपकी, कोई आपने रेसिपी बनाई है, उसको भी अपन ऑपरेट में पेटेंट में जा सकते हैं। आपका नाम है, टाइटल है, कोई शॉर्ट फ्रेज वगैरह है, या एनी सच काइंड द ओरिजिनलिटी ऑफ द लिटरेसी वर्क है, ये सारी की सारी चीजें आपकी पेटेंट में जाएंगी, ना कि आपकी ये कॉपीराइट में जाएंगी। भारत सरकार ने अभी, हरियाणा सरकार में अगर अपन कोई पेटेंट कराना चाहते हैं तो सबसे इम्पोर्टेंट चीज है कि यहाँ पे एक डिपार्टमेंट ऑफ साइंस एंड टेक्नोलॉजी है जो कि पंचकुला में सेक्टर 4 में है, सिचुएटेड है। तो सपोज समवन वांट्स टू बी गो फॉर द पेटेंट, डिजाइन पेटेंट, कॉपीराइट, तो वहां पे गवर्नमेंट ऑफ हरियाणा ने एक सेंटर बना रखा है अपना। तो वहां पे क्या है कि आप अपने आइडियाज को वहां पे, अपने डिजाइन पेटेंट को या आप अपने कॉपीराइट को वहां पे आप डिस्कस कर सकते हैं। तो दे विल प्रोवाइड सच काइंड ऑफ द फैसिलिटी टू all of the students, faculty members, or anyone entire which is residing in the state of the Haryana. This is all about the intellectual property right. On behalf of the, thank you very much, Honorable Principal Ma'am, Honorable Dr. Seema ji, which is doing work hard since last over the 15 days. Continue touch with me. Thank you very much, everyone.
Thank you, sir. Thank you very much. Thank you for sparing your valuable time.
Thank you very much, ma'am. Thank you.
I deem it a great honor to propose the vote of thanks on this online national webinar on intellectual property rights. I, on behalf of M.D.S.D team, extend a great hearty vote of thanks to our resource person, Dr. Vipin Saini and Mr. Pranav Rajput, for enriching our knowledge in the field. I also wish to express my profound gratitude to the organizers. First of all, the head of our institution, our worthy, dynamic and beloved principal ma'am, Dr. Kiran Angra, whose exemplary wisdom is the foundation of this seminar. Mrs. Nishu Bansal, organizing secretary, who has left no stone untouched for organizing today's seminar. We are also very thankful to our colleagues from different colleges and student participants who have turned up in such a great number. Once again, I am very thankful to all of you for your cordial cooperation. The feedback link we are sharing in this chat box, and the certificates to the participants will be mailed to their personal email.
Kindly switch on the camera, please. Thank you, everyone.
We have shared the feedback link in this chat box. The link will be available for 10 minutes.
हाँ सबमिट कर दिया। चांस की बात है बिल्कुल।